Okay, although this matter had been listed for referral to special mediation drive for the nation, the learned counsel for the petitioner has prayed for being permitted to withdraw the repetition in the present form. Full stop. Accordingly, the repetition is closed on withdrawal. Professor. Yes.
I please your lordship, with the consent of the other side, I beg to mention item number 15 today's
One
date
five.
is 1/5, yes, lordship.
Ah,
The engaged counsel has some personal difficulties, lordship. Better
yes,
will please over for the day.
we will take it up. See what is the matter. We will not go adverse against you for today.
Okay, lord.
Yes,
Petitioner, lord.
we'll have it. We'll take it up. We'll see that no adverse orders are passed as on today, but we'll have to write something in it.
Yes, lordship. Much
Yes, madam.
Wait, please, your lordship. I beg to mention item number 29 of supply list, lordship. Kindly pass over the matter for the day, lordship. In your council is workstation, lordship. Kindly fix it on 5th, lordship.
It was fixed today. Your council desires to have some out-of-station matters today fixed. What can we do?
Lordship, kindly fix it on 5th.
On?
Lordship. 5th. Day after tomorrow.
Day after tomorrow. The request has been made on behalf of the learned counsel for the petitioner for listing the matter day after tomorrow. Accordingly, list it on the 5th of February 2026.
Mass of lordship.
The second time before you, lordship. Annexer is page 13, lordship. FIR is page 13.
Page 30.
Yes, 1/3.
1-3.
Yes, ma'am. The allegation was that petitioner introduced the co-equals with the informant as an officer of a railway department and thereby both of them misappropriated money from 40 persons, different persons known to the informant in the name of providing jobs, lordship. But they failed to provide jobs. This is the allegation. But lordship, the fact is that the first case regarding case for job scam was lodged before the Sunbury police station, lordship, against the informant along with 15 other persons. This is the annexure 2, page 21, lordship.
Page 21.
21, lordship.
Ah,
This was lodged on 8/8/2025, lordship. It's the first case against the informant. His name was appeared in serial number 15.
serial number?
15. Page number 20, lordship.
Page number 20.
20, lordship. FIR. Format of the FIR, lordship.
Ah,
This is the name of the informant Jiten Kolita, lordship. And he approached before this honorable court, and after getting an interim protection from this court, lordship, to counterplus this affair, he lodged the instant ejahan, lordship, against the informant, petitioner, lordship. As the petitioner,
original FIR is lost by you.
yes, lord. I am the one of the witness in the said case, lordship.
You are one of the witnesses
Oh.
in the said case.
Yes, lordship. That is page 25, serial number 4, lordship. The accused petitioner name is declared as witness.
Serial number?
4, Nilomani Nath.
Ah,
And lordship, after getting the interim protection from this court, lordship, only to counterplus the FIR and to take the revenge against the petitioner, he lodged this instant FIR, lordship. But the fact is that, lordship, before registering the Sunbury PS case number, no case was registered against any of them, lordship.
after this FIR, no, the one against you, the one where you are a witness was not registered as an FIR.
No, the case was registered as
Ah.
Sunbury PS case number 203, and the informant appeared before this court, approached before this court, for getting pre-arrest bill, and the annexer 3, page 26, lordship. This is the order of this court. And the informant get the interim protection on the first day, lordship.
Page number?
26.
The one who has lodged an FIR against you,
Yes, Lord.
he has got bail.
On a first day without present the case diary.
Hmm.
And after getting this protection, he filed this incident case against the petitioner. The other co-accused, that is accused number one also get the bail from the honorable judicial magistrate.
Counsel appearing for the petitioner. Who is the APP? Let the APP come. The APP might be.
Oh, right.
Yes. You agreeable for the mediation or you want the adjudication? Mediation. Agreeable to agreeable. Agreeable or the mediation agreeable? February, when can you appear? In the mediation center, give us a date. 16th?
16th of this month. Yes.
16th of February, no? Before the mediation center, I would appreciate 25th of February before this court, with the report. Oh. মেলা গেল 16th of February mediation curriculum next week দিব না লাগে
Mediation date will be required.
list thereafter with mediation report.
May it pleases your lordship. Lordship, matter pertains to family pension, so may the matter be kindly sent for mediation.
Oh, this is withdrawn. It is withdrawn. Yes, sir.
Your lordship, otherwise the matter is covered by Rafiq Masih. Recovery after 13 years.
So we don't want a mediation here.
No, Your
I don't know. It will lead to the same thing.
Same.
Either you agree for Rafiq Masih there,
Yes, my lord.
you disagree, comes back, we say Rafiq Masih applies.
The-
Or we say today here, that Rafiq
My-
Masih applies.
Not today, my lord.
Not today.
I may be
Tomorrow.
exempted from arguing today
Tomorrow?
only. My lord, on next Monday,
Next month.
Tuesday, my lord.
Okay, not agreeable for mediation. Connect Council submits it, it's a covered case.
Tuesday, like,
Then at the CDC, please that the matter may be taken up for disposal on
my lord, 10, on 10th
10th.
of February.
10th of February 2026. Will Rafiq Masih or not?
Deeply obliged. The chances are very less, but even then, my lord, let it be fixed on 10th and matter can be disposed
Yes,
of.
we'll dispose it of this way, that way.
Deeply obliged.
Either you recover or you don't recover.
There is an interim order play here.
Interim order continues.
Highly obliged.
Deeply obliged, my lord.
This is item 5. 4. So mediation or adjudication? Yes, madam. Mediation, agreeable mediation. Yes, madam, you would like to oppose? No. Decaded video, na? Decaded video mediation.
Cannot be sent to mediation, my lord.
Cannot.
We are serving under the corporation, whether we are entitled to compassionate family pension scheme or not. They have filed an affidavit stating that we are not government employee, but our salary has been disbursed by the parent department, Plain and Times Development Department. They have now taken a stand that we are not entitled to any benefit.
When it is not agreeable, when do you want it?
Only that much.
Affidavit has been filed by
Yes.
them. You have filed your reply.
We have not filed it.
You don't want to.
Verify, my lord. Next week, any day.
Uh-huh.
Next week,
No, if you want to file a reply, we'll give you 2 weeks.
yes,
If you want to go through it, we'll have it day after tomorrow.
we'll file reply.
Not agreeable for mediation. The counsel for the petitioner submits that he would like to file an reply to the affidavit in opposition filed by the respondent authorities, list the matter again after the 24th of February. Yes, sir. Where is the charge sheet?
Pardon, ma'am?
Where is the charge sheet?
Yes, my lord, I beg to submit,
Ah.
if my lord permits. My lord, actually, in fact, there are three cases.
Hmm,
This 486124,
hmm,
Randhir Kumar versus Union of India, and my lord, 19/25,
hmm,
both are filed here, my lord.
hmm.
And my lord, in the first case, 4861, we got to stay from 20th/11/24.
Which was vacated on the last
That
occasion.
last order.
So
Well,
therefore, we would need to
Another
different-
number 5792/25,
Hmm,
that was in Itanagar.
ah,
That came back here with the, it is
No,
now
no, it's
clubbed
not-
together.
subject
Well,
matter was the same.
there also we got a stay by Honorable Justice here, Surana, 4th of April, by a very detailed order.
Ah,
Well, that 4th of April 25 order, he has delivered the entire issue on the subject matter. Because these are all the club cases arising out of my lord common proceedings.
hmm,
Fourth, I beg to draw my law's attention to 4th of April order.
Lordship. As a matter may be passable for the time being. Mr. Agiri Chowdhury is
If
in
we are
next
passing it
number.
over for the time being, madam, then, once Deputy SG appears, we'll take it up for disposal.
Yes, sir.
If you are not prepared today, then we'll take it up some other day. Would like to have some? Yet now, the interim once vacated by a particular order,
My lord, what happened, my lord?
not inclined to extend the interim. So today I cannot change the entire order
No,
to
my
say
lord,
that we are extending it.
With due
Extend
respect,
what?
with due respect, I
Hmm.
beg to submit, my lord. They filed an IA for vacation of the interim order. I replied the IA.
Hmm.
I was not present that day.
Hmm.
My associate was indisposed. So my lord, she was incapable to submit appropriate. Resultantly, my lord, with a single line order, without disposing of the IA filed by the respondent, the interim order was quashed, my lord. My lord, if my lord have a look of 4th of April order, my lord will, I believe my lord will appreciate the entire
what-
case.
what-
4th of April. I just,
We do not,
4th of April order, my lord.
one court has decided not to, it will not be, we cannot say that it was this court, that court, that court, that court. It is the
Yes.
Guwahati High Court. Let
Yes,
us take it to be there. Now, once this court expresses a mind that we are not inclined to extend the interim order on the basis of materials on record,
Yes, ma'am.
there are ways and means to have this order modified.
Yes, Lord, but I did not
Lordship,
ask
in
for
fact, the court has heard on length on the interim lordship on the
In
last.
case the
hearing.
petitioner's counsel was not able to place the case
Lordship.
properly.
Lordship,
It
But
happens.
IA
It
has not
happens.
been
It
disposed of.
happens. With everybody, it happens.
IA has not been disposed of.
Could be. Effectively, it has been now.
Yes, ma'am.
So now, if we take it up on a convenient date,
My lord,
or
Saturday,
if we take it up today, we can take it up today, bring it to a final
Yes,
finding,
Lordship, after some time.
Here?
Lordship.
or maybe on the first floor.
my
we'll
lord,
have
I am
some-
ready for final hearing today itself or
Ready?
in Saturday as per my lord's convenience.
Lordship, there is difficulty on Saturday.
Let us
day
not
and
fix
Saturday.
anything on Saturday till the fourth, please.
Today I am
On
ready,
fourth,
my
we'll
lord.
start fixing, huh?
Or Friday, Saturday, any date.
Today also we can do it.
Today, yes, my
He
lord.
is
Yes.
Today only,
asking
based
for
on-
some time
for
for the
some time.
deputy.
At
SGF
12
to-
o'clock, my lord, it will be convenient.
We'll not fix a time, but we'll take it up as soon as possible.
Deeply obliged.
Obliged.
The time being good, huh?
In the meantime, my lord,
Ah,
In the meantime, may I submit a convenience note if permit?
I had one, there was one available.
No,
This is a
Recently, I
newer-
made also adding
Philip.
many judgments.
Yes, sir.
Kindly finish the last. one.
Oh,
Yes,
yes. Who appears for the education department?
File affidavit, Lordship.
Show us one person who can do PhD in 2 years. No, show us one person.
Lordship,
Just one. Before 2 years, this man has done PhD. Course series of 3 years. You are asking someone to, that you will be regularized if you can pass matriculation before you are 13 years of age. Oh, the minimum age is 15 years. Be able to do it.
Lordship, one chance to file affidavit in new case, Lordship, on 11th, the file 2511 cases filed. Well, non sanctioned, three
Just-
times, Lordship, we file it.
Just try to ask the department.
Yes, Lordship. No, yes,
PhD is of 3 years.
Yes, yes, I got
you
your
give a
point.
condition of 2 years.
Yes, I got your point, Lordship. I got your. Point. Yes,
When?
yes, I got your. Point.
When?
After 2 weeks, Lordship.
2 weeks. Look at it. Look at it.
Your loss.
At the request of
Senior higher,
Senate Standing Council,
higher division.
appearing for the Higher Education Department. Is this matter again on 16th of
Yes, sir.
February? The respondents would be at liberty to file their response to the writ petition. Full stop. The learned who gave you the regularization order? Regularization order?
Order Lordship, two orders. One is by government and another is by the director.
By the, no, show us the order.
Well, Union order is at page 47. And
No,
another
no, no,
Lordship I had,
I said your regularization
no,
order.
yes, that is your Lordship, page 20.
20.
20.
The learned pending counsel for the higher education department would have specific instruction. Where is that sentence for 2 years? Specific instruction as to whether. Oh, we could have qualified net and slate, not only PhD. Not only PhD, you could have qualified net and slate. Why did you not do that?
Not, that's why fixed payment is given.
I understand. You have to qualify either net or SLAT or PhD. PhD is 3 years. Net and SLAT,
Minimum 3 years and the,
net and SLAT.
Yes,
Why did you not do net and SLAT?
well, he should.
There is a catch. Okay. List again on 16th of February, the Learned Council will have specific instruction letter. At best, revert back to them since you have got the qualification now, a reconsideration of the earlier condition. Mandamus is difficult. We are giving you a mandamus is difficult. Yes. Okay.
Lordship, I placed the instructions. The instructions should. 20. Issued instructions.
What was the prayer?
Prayer was for grant of regular pension.
Ah,
So as per the instructions, all the pensionary dues has already been disbursed.
NPS. So if required, we'll return it.
The prayer was to provide regular pension scheme for the retirement benefit of the.
1611-2025. Then why is he saying that his master roll service?
He was in fact promoted also in
Huh?
2000. He was promoted also in 2019 as rigman. As per the instructions, Your Lordship. Second page. Thereafter retired from government service on 31/3/2019, and accordingly he has received all pensionary benefits as admissible under the NPS rules. since after 2005, NPS came to be implemented.
When did he first join as a master worker?
First joined, Your Lordship,
He was regularized in 2005.
yes, that only he has actually annexed the appointment letter of 2005 as Annexure A. But with regards to his joining, also let me just go through Annexure A.
Someone appeared on the last occasion.
Yes, otherwise he joined as at page number 14
Huh.
on 18/11/88, serial number 16, 13 years.
So, that entire period for, in other cases, it was taken into consideration for
Consideration.
pension.
For pension.
In this case, it should have been.
It should have been because past
Yeah,
service,
because
because he has annexed that OM also to
Ah,
this.
So that OM says perhaps that the past service will be.
Past
counted for
service will be
pension.
counted.
Non-APS, what do we do after some time?
Lordship,
Call up Bishop. Let us scroll video. After some time, if it is Mr. Bora? Mr.
Yes.
Bora, after some time?
after some time, after some time.
I'm repairing it.
Ah,
I said, this is what this is for.
you have been protected well by Mr. Bora. Yes, sir.
Education department. Secondary.
What is the matter about?
Matter, Your Lordship, this matter relates to selection and appointment of graduate teachers, Your Lordship.
Are, if they come up with some reply, are we prepared for disposal?
Your Lordship, we will not file any reply, Your Lordship. They have filed their affidavit. Oh, we have filed our reply
Okay.
also.
And let us take it up. Someone
Lord.
comes, it is. Okay.
8 number of petitioners are there.
Ah.
Now, they all belong to OPC category, Your Lordship.
Hmm.
There is an advertisement, Your Lordship. That Your Lordship will get it at page 25.
Hmm. Hmm.
There are altogether 7,249 vacant posts, Your Lordship. And accordingly, Your Lordship will kindly come to page 27 for a moment, Your Lordship. Page 27, Your Lordship, got it.
Yes,
Now, Your Lordship, it comes to page 25 is the advertisement, Your Lordship.
we have seen that.
Lordship. Then page 27, Your Lordship.
Page 27.
27.
Yes, sir.
Criteria for selection of graduate teacher.
Hmm.
Your Lordship will kindly come to this, Your Lordship.
1:1 advertised.
F. In case of any post remains vacant after publication of the first merit list,
Hmm.
as per the ratio 1:1, then maximum 2 more numbers of merit list will be published, Your Lordship.
1, 2, 3, yes.
And Your Lordship, then Your Lordship G, next page, there shall be merit list stream wise, arts, science, Hindi, Sanskrit in case of graduate teacher, Your Lordship. Now, Your Lordship, subsequently they have issued the corrigendum, Your Lordship also. Your Lordship will find that, Your Lordship. Page 40, Your Lordship. Addendum. Number of, then we applied, Your Lordship. Now, we applied, Your Lordship, we call for the interview, Your Lordship, for documents verification also we are called, Your Lordship.
Hmm.
Now, when Your Lordship, they have published certain list, Your Lordship, that is for document verification. At various point of time, they have been publishing list, Your Lordship, for document verifications. And in fact, Your Lordship, they have not disclosed the reason why certain number of candidates were rejected and whether against them some people are called or not, Your Lordship.
Mm.
At the relevant point of time, we came before this honorable court, Your Lordship. Now, ultimately, they have issued the final select list, Your Lordship.
1, 2, 3 or 1?
One.
1, okay.
One, Your Lordship, issued, and in fact, Your Lordship, there is no select list published, Your Lordship. What they did, Your Lordship, they issued individual letters to the communication to the selected candidates.
Mm.
Till date, Your Lordship, we don't know how many of candidates, Your Lordship, has been appointed, who are the candidates appointed, what is the marks obtained by them, Your Lordship. This has not been, Your Lordship, disclosed, Your Lordship. Now, ultimately, Your Lordship, we have raised grievance that there are certain posts remain vacant, Your Lordship. Those posts for various reasons, certain persons were candidates were rejected on the ground of their application, Your Lordship, their qualifications on the last date of submission of the application form was not there, Your Lordship. Some there are fake documents, Your Lordship. And in this case, Your Lordship, I have also raised the point, Your Lordship, that when so far as the reserve category candidates are concerned, who have secured more marks than the general category candidate, they should have been, Your Lordship, brought into the general category list, Your Lordship.
That
That has,
if they taken some benefit of the reserve category, saying age,
Lordship.
then they would remain as an OBC even if they
That's
secured more marks.
probably, I did not bring it, Your Lordship, latest judgment, but that, apart from
No,
that,
there
Your
are two cases. One is a compartmentalized reservation, one is an open reservation.
Lordship,
If it is compartmentalized,
Lordship,
matter ends.
Lordship.
One benefit remain in the
Lordship,
company.
that's what.
It will be watertight.
Now,
And
Your
if it
Lordship,
is open, you have to see whether the OBC reservation in Assam is which.
Lordship, the point is, Your Lordship, I will not, Your Lordship, got
Go to bed.
that, Your Lordship, but is ultimately, Your Lordship, they have filed an affidavit. Your Lordship.
What did
By
they say?
filing the affidavit, Your Lordship, they say, Your Lordship, here also, Your Lordship, in this particular case, Your Lordship, they have not mentioned the number of posts they have filled up, Your Lordship. That is not disclosed. But, Your Lordship, in the second case, Your Lordship, the other case, Your Lordship, in the affidavit, Your Lordship, they have not made any pairwise reply, Your Lordship. There is a general affidavit, Your Lordship.
They have only asserted their right to
Right to
cancel
present.
candidatures if they don't find it correct. Yes.
Lordship.
What is your prayer?
Now, Your Lordship will kindly see in the second case, there is an affidavit, Your Lordship.
Ah.
Now, in that affidavit,
Second, sorry.
53 WBC 5639.
5, 6. Listen. Ah.
Now, if Your Lordship comes to para 7,
Were your documents verified?
yes, documents verified, Your Lordship. That there is no dispute about that, Your Lordship. Now, Your Lordship will kindly come to page 74. Your Lordship will find they have filled up, Your Lordship, 6,240 posts of graduate teacher. That means, Your Lordship, they have left out around 1,000, more than 1,000 posts, Your Lordship. ZT, Your
Oh,
Lordship.
What was the number of posts? Advertise 7,200.
Lordship. They have
1,000
6,240, they have, your lordship, filled up.
Hmm.
Now, your lordship, my case is, your lordship. Of course, your lordship, there is no doubt about the proposition, that no quarrel with the proposition, that it is for them to whether to appoint or not, your lordship, go for press selection or not. Otherwise, your lordship will, if your lordship sees this affidavit, why they have not filled up this post, your lordship, that has not been disclosed by them, your lordship. That too, when the advertisement was very clear that, your lordship,
Did you meet the cutoff mark in the respective?
no, your lordship will kindly see, the cutoff mark, your lordship, it is not that, your lordship, they have set a cutoff mark and thereafter, your lordship, they have verified. What they have did, your lordship, they have called 1,000 people, your lordship,
Hmm.
suppose, your lordship, that serial wise, your lordship, posts are 700, your lordship, the last point, your lordship, is the number, last marks is the cutoff mark, your lordship, last candidate mark, your lordship. That's that way, your lordship. We are not there within that, your lordship. Therefore, we are out. No doubt about that, your lordship. But the point is, your lordship, why they have not gone for, your lordship, in spite of the specific mention about 2 more select lists, your lordship, which they said they will, your lordship, in the advertisement. And in spite of there being vacant posts, why they have not gone for filling up this post, your lordship, in the same advertisement? And your lordship will kindly see, your lordship, in the affidavit also, they have not shown any reason as to why they have decided not to fill up this post, your lordship. It must be reasonable, your lordship. Their discretion is always there, but the exercise of discretion cannot be arbitrary, your lordship. The exercise of this discretion must be based on certain reasons, your lordship, which ought to have been disclosed before this honorable court, your lordship. They have said that they have the discretion. It's all right. They have the discretion.
It was the sentence where they would,
And secondly, your lordship will kindly see till then, although it is the mandate of the rule also, your lordship, that they should notify the select list, your lordship. That select list has not been notified for the public view, your lordship.
what is the mode of notification?
Your lordship will
So
kindly
what will
see-
be the mode of notification? Notification is required, we understand.
Lordship, your lordship will kindly see the
Newspaper
rule, your
or,
lordship. Rule 10 of the 2020 rule. Sorry, 18 rule, your lordship. Rule 18.
Rule?
Rule 8. Rule 3, your lordship. And secondly, your lordship will kindly see the rule 1, sub rule 1. The requirement of post of graduate subject post including subject teacher in vocational subject in the provincialized high school, high madrasa, secondary reference in your school shall be made so and so. Before the end of the year, member secretary of district selection officer constituted under shall ascertain the vacancy position of the post in the cadre of graduate teacher, postgraduate teacher, including subject teacher in vocational subject in provincialized high school, high madrasa, higher secondary schools under which is the sanction number, allotment, retention orders, post, invite application for an advertisement to be published in 2 local newspapers. So now your lordship, if your lordship sees this, your lordship will find that your lordship, they will have to, your lordship, find out the vacancy position, then advertise, then appointment, your lordship. If the-
Vacancy position is ascertained 7249.
No, then your lordship, they are going to appoint it, your lordship. So your lordship, my case is this, your lordship, once you have ascertained the vacancy position, advertise it, your lordship, and at this, the mandate of the rule, although not specific, but your lordship, if your lordship sees to the rule, these posts are required to be filled up, your lordship. That is why they said that the rule says that before going for advertisement, you ascertain the vacancy position, then go for advertisement. It is not a stopgap arrangement, your lordship. And before end of the year, your lordship will kindly note that. That means, your lordship, in each year, they will have to go for that, your lordship. So that means the vacancies that have come up in a particular year, that will have to be filled up by the said advertisement, your lordship. They cannot now come and say that it is our discretion whether we will fill it up or not, or we will go for a second advertisement to fill up. And for that, they will have to show some reason which is acceptable to this honorable court, your lordship. And in the instant case, that has not been done, your lordship. I am relying on one judgment, your
So
lordship.
your prayer is to declare what?
My prayer is to your lordship to fill up the entire vacancies, your lordship. Your lordship will kindly come to my
You are sticking only to 4
lordship,
at page 22.
lordship,
Is it?
lordship.
At page 22, let us see this thing. Direct the respondent authority to publish the rejected list of candidates. You are not concerned
No,
with them,
no,
you are
no.
not one of. Direct the respondent authority to eliminate those candidates whose name appear in 2 different subjects. And call
Direct
for
the
new
respondent
documents.
authority to fill up the remaining 1300.
So only
That-
4 is
that's-
what?
that-
4
that-
is your
Lordship, that.
relief that you
Lordship.
seek now.
Now, your lordship will kindly come to one judgment I am relying on, your lordship will kindly see. While Yes, para 5, your lordship. This is the, your lordship, quorum is of 3 honorable judges, your lordship. 2 judges, Honorable Justice Joseph and Honorable Justice Deepak Gupta, your lordship.
Para?
Para 5, your lordship. The main issue which arises before us, whether SCECR would have ignored the 20% extra penal despite the letter dated 2/7/2008 without giving any cause and reason for the same. No doubt, it is true that mere selection does not give any vested right to be
So
selected
this is
candidate.
about selected candidates.
Lordship, that's so, but the lordship can kindly go next line. At the same time, when a large number of posts are lying vacant and selection process has been followed, then the employer must satisfy the court as to why it did not resort to an appointed selected candidate even if they are from the replacement panel. Just because discretion is vested in the authority does not mean that this discretion can be exercised arbitrarily. No doubt, it is not incumbent upon the employer to fill up all the posts, but it must give reasons and satisfies the court that it has some grounds for not appointing the who found place in the replacement. In this behalf, we may refer to so and so. Ultimately, your lordship, some reason, your lordship. And when your lordship rule, your lordship specifically says that each year they will have to undertake an exercise, your lordship, and that will have to be they will have to bring it to a logical conclusion, your lordship, by appointing them, your lordship. And otherwise, in the rule, in each year, that would not the reference to the particular year, that would have not been there, your lordship. And even today, your lordship, they have not disclosed to this honorable court, your lordship, that why they have decided not to fill up this post, your lordship. This is, your lordship, my case, your lordship.
But unless you come within the cutoff, whatever means, if the merit list somewhere you are not there in the cutoff.
Now,
then,
so far as your lordship will kindly see the cutoff,
how
I
did
will,
they reach the cutoff is one thing with.
your lordship will kindly see the manner in which cutoff is done. Cutoff has been changing in each verification process. It is not that they have fixed the cutoff,
No, there will be 2 kinds of cutoff.
lordship,
What we understand.
lordship.
First is anybody below 50% we are not
Yes,
bringing in. So
that
that is
is
one cutoff.
the,
Now, above 50%, the number of posts is 100 and we have 10,000 candidates. The first 100 would stop at, say, 80%. So the second cutoff is 80%.
lordship.
Now, when they call the 80% people to the selection process, now they find that 20 of them are not eligible for whatever reasons, fake document, whatever reason. So now they will say, we'll call in some more people. They call in some more people, they find the cutoff stops at 77. So now we have got a third cutoff. Even some of them don't join or some of them don't come to accept, or they are double categories. They call in some more people. Comes down to 75. You are somewhere at 72.
Then
How
Your
would it
Lordship,
help?
I am out.
Out.
Then out, because here is the case, Your Lordship, when advertisement says there will be two more lists. And
Those are the two more lists.
no, they have not published two more, Your Lordship. Only one list.
That is one question.
Your Lordship will kindly see, they have clearly said, and now they say in the affidavit that that is their discretion. They may not go for the second and third list, Your Lordship. Although they have not published any list, Your Lordship, till date, Your Lordship, but they have issued appointment orders to the around 6,200 candidates, Your Lordship.
Okay.
Now, the purpose, Your Lordship, if Your Lordship conjointly read the rule and the advertisement, it's very clear that every
Fill up all the
approved
posts.
will be made to fill up the
All the
posts advertised, Your Lordship. That is in tune with the rule, Your Lordship.
Yes, Mr. Khatonia.
First of all, my lord, they are not within the cutoff, my lord.
That we understood.
If they are not within the cutoff, then how can they claim for a,
He will come into the cutoff according to him. He has a chance of coming into the cutoff.
There-
For the second and third list. In the first list, admitted list. Now, advertisement, you said you would have a second list and a third list. The judgment that has been given to us, I don't know whether you have a copy,
no, my lord.
it speaks of a replacement panel. Someone goes out, this man
Someone
will
come.
replace him. That replacement panel factor comes in. Now, when you give the assurance that you will have three lists, can you still stand up to say, we may have said so in the advertisement, now we decide. That is the first question. Second question, somewhere I have read in your affidavit just now, admitted position is you did not have different cutoff lists or different lists for the different category. Is it so?
That, my lord, I'm not sure, my lord, that. Because 5, 6, 6.
And thirdly, this court would also like to know, there were some litigations where posts are asked to be kept vacant, not to be filled up, so on and so forth. Education department, there will be some litigation. So, although you have not taken that ground in the affidavit in opposition, we will not allow you to take that ground in the during arguments also, rest assured. But any number of posts, if directed to be required to be kept vacant by this court and we pass an order affecting those cases, then it will not be correct, contrary, overriding the orders. So that much information we require as to the number of posts in graduate teacher category, which have been ordered to be kept vacant by this court, if any, so that our order does not infringe on the merit of or the order passed in that case. That is one thing. And I read that sentence very good. In the other affidavit,
Yes, my lord, I think, my lord, paragraph 8. The
Eight.
second, second case, my lord,
Second case, no?
5639, paragraph 8, my lord.
Somebody has admitted that it has not been done category wise.
Not category, my lord, they have said, here, my lord, we have said that since they have not qualified, so they have no right or claim
No,
to,
no,
for
no, no.
publication for second merit list.
Read that particular sentence.
There are 5 units.
Para 7. The
Yes,
answering deponent while denying this and reiterates the statement made herein above. And furthermore, Besu said that no subject-wise and category-wise merit list for the post of graduate teacher has been published till date. Without doing that, could you have gone ahead with the selection process? Let us have the advertisement for a
Yes,
minute.
yes, my lord.
Advertisement is a page.
Page, my lord, 28, my lord.
It is postgraduate teacher. We need something on the graduate teacher. Where is the graduate teacher?
Page
Here.
Page 28.
5366.
Page 28 is postgraduate.
Postgraduate, my lord.
But-
Next,
It starts from your
next 34, my lord, 34, my lord.
We are on graduate teachers now, sir. Is it?
25 euros.
We are on graduate teachers.
কোন কোন বটন দৌড়টি না?
There shall be a separate merit list subject-wise in case of postgraduate teachers. In case of graduate teachers, you don't need that subject-wise.
Page 28.
28 is postgraduate, sir. That is not
No, there
confused.
shall be a separate merit list stream wise.
That is for postgraduate
Sir.
teacher.
No, we are not.
Oh, yes, that is an advertisement for postgraduate.
I think my lord is having the second case, my lord. He's referring the 5366. In 5366, it is in page 25.
We are not on pages, sir. We are on two different advertisement. One is for postgraduate, one
yes,
is
yes.
for graduate.
That is, my lord, in page 25, this is graduate teacher advertisement, my lord.
Of WPC number.
WPC, my lord,
53.
Five-
Now we will
53.
confine to 5366.
5366,
5366,
page 25.
page 25. Yes, page 25 is for
Graduate teacher.
Graduate.
graduate. And there shall be one common question paper. There shall be a separate merit list stream-wise,
Stream-wise,
part
part
time
time.
Hindi for, in case of graduate teacher.
Yes,
That
Where is it?
it is there, my lord.
Where is it?
That, my lord, from the affidavit,
See, will number of posts you want to fill up or not fill up, will come to later. The second and the third list, in case there is a reserve list or a other list, you could not have denied them. Our AFR, BM or whatever that says, no waiting list.
yes.
But it does not say that in case posts are not filled up and you have already announced two merit lists, still you will not bring in the second and the third list. It's coming. Your select list is for 1 year. So till now, you are working on merit lists.
Yes.
Ultimately, there has to be a select. Now you have appointed persons from the merit list. Have you not?
Yes.
Without preparation of a select list. Therefore, no publication of a select list. Could you have done that? Could you have done? Not done. Those people are not before this law. We will not interfere in their appointment. However, keeping the appointment intact, we may still direct that the merit lists have to be completely prepared. Out of that, choose not to appoint 1,000 with a reason. But the persons above that have to be appointed for the select list. So the publication of a select list is a must. By that logic. Without a select list, how can you appoint on a merit list?
In fact, this clause Z, my lord, this speak about the merit list.
May, there shall be separate merit
Merit
lists in yours.
3 months.
Merit, what is the difference between a merit list and a select list?
Merit list, after comparative statement, those who are within the zone of consideration, that is merit list. Out of that merit list, the person.
You did not have any cutoff initially slated. So therefore, everything is a merit list. Any person whom you allow to appear, their merit has to be assessed. Yes. Provided they are eligible. The first thing to see is whether they are eligible or not. Your documents, your everything. Now, those people you find eligible without doubt beyond the scope of forgery, everything. Out of that, a merit list will be formed. Thereafter, you go ahead to make the selection. How? First, vertical. Cut off at the number of unreserved posts, take them away. Then you start with the horizontal reservations. Vertically, you bring in the ST, vertically, you bring in the SC, vertically, you bring in the OBC. Thereafter, you look for the PWD, insert them horizontally wherever you want to. Economically, weaker section, insert them where it fits in. That final cutoff, the total number of posts and the total number of candidates, is the select list. You never had one. You had a merit list for unreserved. You had a merit list for
Reserve.
ST, SC, OBC. And out of the merit list, you started appointing. Can that be done?
That
Can that be done? Could that have been done? If not, then what do we do with the appointments made? And how do we get the select list? How do you get the select list from number? Number two, when the merit list has not been completely made because persons who were found ineligible have not been replaced by persons who were eligible but could not make it on the merit because of ineligible candidates. As they come in, the merit list is not complete. How can appointments be made on the basis of an incomplete, forget a select list, an incomplete merit list now?
my lord, that instruction I have to obtain because my lord,
The writ petition is before you.
is
Questions have been raised.
is.
Now, one thing we are not happy is Mr. Bhattakur has given away the other prayers. If the other prayers are given away, he will not come into the merit list.
Other prayer, Your Lordship, no, I have
One,
not.
two, three.
No, Your Lordship, I have not given away A, but what I am saying, Your Lordship, that even going by their affidavit, prayer number 4, they should go for that, Your Lordship.
Now, is it much difficult to come up with a proper select list, even at this stage?
No, my lord,
Should not be.
should not be.
A reason why only 6,200 have been appointed and 7,200 have not been filled up. You may have your own reasons. We decided to fill up, we are short of money. Here, any and every reason in conceivable. The reason has to be there. We will interfere only if you have appointed someone below merit and not appointed the petition. We will go for an order of revocation. Otherwise, there has to be a reason before this court. Not giving the reason to this court is another problem.
Yes.
And once you have made appointments, how difficult it is to come up with a select list?
So it is not difficult otherwise.
Perhaps an answer would be, we have considered the merit list to be select list. Yes, possible. Tell us. Tell us that the merit list was the select list. Why is it difficult to spell it out? Difficulty cannot be there. Your advertisement says you would have a separate merit list stream-wise. And in this, it is the same advertisement or a
Yes.
separate advertisement.
Same.
Cannot be.
These are Your Lordship.
Then why that clause is not there in that advertisement?
That is for referring to.
These are postgraduate teachers.
No,
Postgraduate.
there is a graduate teacher advertisement also here. That is what. You said page 25, did you know?
Yes.
In this case,
Just a
your
minute,
lordship,
just a
28.
minute. Just a minute, sir. Should be. Is an extra B.
This is an addendum, your lordship.
This is also post.
They have, your lordship. Since this case relates to postgraduate teacher, your lordship, you have.
There is one case relating to postgraduate and there is another
Another
case
to
relating to
graduate.
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 What is the third case? Who appears in the third case?
I, your lord. They are arts, your lordship. In
We
this
are
case,
taking
they
up
have not
item?
filed their affidavit.
We are taking up item
33.
Huh?
32. 32. my lord.
30, your lordship.
No, next 30 to 30.
30.
32. 32.
30, 31
32, my lord.
and 32. Three of them are there.
Yes.
So one is of graduate teacher,
Third.
one is of
Postgraduate
postgraduate.
teacher.
And the third
Third
is of,
is also graduate, your lordship. They came late, your lordship, therefore, your lordship.
anyway, only those two cases can be taken up together.
Lords
Ah, yes. Where is the other one? Dorothy
and Juhisri, your lord.
Dorothy and
Juhisri.
Juhishri, they are
Juhisri is your lordship, postgraduate teacher.
postgraduate, and 5370
That is
Gayatri,
graduate, your lordship.
huh?
Graduate.
Graduate. So, item number 30 and 32 are to
32.
be together. So we'll not take up 31 for the moment.
Lords.
Let us have it sorted out. We'll select list wise. What is their affidavit in this, sir?
No, they have not filed it.
In 30, we have filed, my lord.
Ah, but we need something in 32.
Yes.
What we have not given in 30
Yes, my lord.
will
Let
have to
them-
be fulfilled in 32.
32.
If it does not come, you want us to record it, we'll record it. But if it does not come, then we will take it to be an attempt to not to disclose
My lord, may record it in the,
all material required for proper adjudication of the matter.
my lord, may record it in the order, my lord.
Ah, yes. So we'll give you a week's time to file your affidavit. The rest of the material is available in item number 30. So no long cut instructions, no comments should do. Specific questions we have raised, paragraph 40.
Yes.
Yes, heard Mr. S. Thakur, Learned Counsel appearing for the petitioner in WPC number 5366 and 5370, huh? Okay, what Mr. S. Thakur, Learned Counsel appearing for the petition. These cases are related to the advertisement issued on
No, no, still on 26/12/2023, my lord.
26/12/2023 with regard to 7249 vacant posts of graduate teachers in different provincialized secondary schools under the Directorate of Secondary Education, Assam. Stop. Was any breakup of the
Breakup, my lord, will find in the addendum, my lord.
in the addendum? The breakup of the number of. Is it the same thing? Page
Lord.
25 and page 31, is it the same thing, sir?
Page 37 is the other.
No, we are on WPC 5366, page 25 and page 31. Are they the same thing or are they different?
31 is your, for your lordship, government schools, your lordship.
Ah.
This
The
other one is for provincialized.
advertisement, the advertisement regarding filling up of 205 vacant posts of graduate teachers in different government secondary schools under the same directorate is also involved in this litigation. both the advertisements had the common criteria for selection, which is the bone of contention in the present writ petitions, namely, you take from page 33 of WPC 5366 or page 33, no pencility A লিখিছো না? From there you take up to page 34. মজুত A লিখি দিছো। That is clause and the criteria for selection of graduate teacher in pencil, hey, কিছু paragraph লিখে দিই। Full stop. The learned counsel for the petitioner has submitted that the criteria for selection had made it explicit that in case any post remains vacant after publication of the first merit list as per the ratio of 1:1, then maximum 2 more numbers of merit list will be published. It was also stipulated that there will be a separate merit list stream-wise in case of graduate teacher. The manner of preparing the merit list has also been given at clause H, giving an example that for science stream teachers, the candidates shall be filtered out from the main list into a separate merit list of science stream. And similar process would be adopted for all the other streams. The learned counsel for the petitioner has further submitted that although the petitioners had been called in up to the stage of document verification, their names did not find place in the merit list published by the respondents on, when was the first merit list published, sir?
That we don't know, Your Lordship, because Your Lordship, there is no.
No, you say you don't meet the cutoff.
Lordship. No, not merit list, Your Lordship, that's after verification, Your Lordship. After document.
There is no merit list published as on date, not even a
Not-
single one.
No, we have not. found.
Learned counsel I'm proposed with you. Learned counsel for the petitioner has submitted that although no merit list has been made public till date, the petitioners were expecting a consideration for appointment since and they had been called up to the stage of the document verification process. In the affidavit in opposition filed in WPC 5366 of 2025, the respondents have not stated as to whether any merit list subject-wise, stream-wise, no subject-wise, stream-wise had been prepared or published full stop. The affidavit is stressed upon the discretion vested upon the respondent authorities to cancel the candidature of a candidate in case the same is found to be ineligible. Full stop. We have noticed, next paragraph, we have noticed that there is no affidavit filed in WPC 5370 of 2025 which raises similar grievance against the very same advertisements in issue in WPC number 5366 of 2025. After some deliberation in the matter, the learned counsel for the it is deemed appropriate. After some deliberation in the matter, it is deemed appropriate by the court to direct the respondent authorities to file an affidavit in WPC 5370, specifically mentioning as to whether separate merit list stream-wise within bracket arts, science, Hindi, and Sanskrit had been prepared prior to offering appointment to candidates who were found eligible and meritorious, whether such merit lists had been published in any manner provided by the Assam Secondary within Education within bracket provincialized schools bracket close rules 2018 or the what's the other rule of 2020? Assam Secondary Education within bracket government schools bracket close service rules service rules 2020. Stop. The respondents would also answer the other allegations leveled in the writ petition. The affidavit by the respondent authorities be filed on or before. I'm just
10
saying, huh?
After 10 days. After 10 days.
10 days. Today we are on 3rd. You were on 13th. On the 13th of February, on or before the 13th of February 2026, the petitioners may file their response with the affidavit on or before 18th of February 2026. Matter be listed again before this court on 24th of February 2026. It is made clear that in case that the respondents are expected to make clear their stand in the affidavit in opposition proposed to be filed, and in case material facts are not disclosed, this court would be constrained to draw adverse inferences.
One more observation regarding the second select list, my lord, because
Yes, the postgraduate.
no, my lord. They have
Ah.
said that
The respondents shall also clarify as to whether any second and third merit lists were prepared as stipulated in the advertisement, and if not, the reasons therefore. This is for the graduate teachers. In the postgraduate teachers also, in the postgraduate teachers, it will be a little different. Shall we retain a copy of those two judgments? Now you take them separately under order for WPC number
5639.
563. Huh? This writ petition involves the advertisement issued on
26/12. 26/12/2023.
26/12/2023 with regard to 1424 vacancies of postgraduate teachers in different provincialized schools and
102.
102 vacancies of postgraduate teachers in different government secondary schools. The criteria for preparation of the criteria for selection of postgraduate teachers had been laid down in the advertisement at clause 2 in the advertisements, in clause 2 respectively, wherein it was specified that the number of qualified candidates wherein it was stipulated that if any post remains vacant after publication of the first merit list, then maximum 2 more numbers of merit list would be published. It was also provided that merit list, separate merit list, subject wise in the case of postgraduate teachers would be published. The affidavit in opposition filed by the director of higher education,
Secondary education.
director of secondary education, reveals that no subject wise and category wise merit list for the post of graduate teacher have been published. And therefore, remaining number of vacant posts in the category of postgraduate teachers were not present. There appears to be some error in the language used in the affidavit in opposition. The matter relates to a court case. A more attentive. The matter relates to a court. After hearing the matter for some time, this court gives the liberty to the director of secondary, to the respondent authorities to file an additional affidavit bringing on record the correct position as may be on or before
Same day.
13th.
13th.
On or before 13th of February 2026. Full stop. The petitioners would be at liberty to file their response to the same before the next date of listing. This again on 23rd of February, 24th of February, 24th of February 2026. The issues raised in the writ petition have not been adequately answered or referred to in the affidavit in opposition filed by the respondent authorities. They would be at liberty. No, they would, therefore, they are directed to bring on record through the affidavit, specifically as to whether the merit list for different subjects had been separately prepared prior to the appointment of the selected candidates being resorted to, whether the said merit list or select list had been duly published as required under the relevant rules and also whether the second and third lists had been prepared and published, and if not, the reasons therefore. List again on the 23rd.
Lordship, 24.
24th of February, usually. As
They-
part of matter.
Deeply obliged.
Always, Lordship.
Two things. Lordship. There was an allegation by someone that there is a duplicate workers' union functioning where this man is a witness. The allegations against whom it was leveled, those persons got an anticipatory bail.
Yes.
Then filed an FIR against this person saying they have accumulated money from us. And we collected money and gave it to them and they did not give us the job. So the money collection was again by the informant himself.
Lordship.
We had rejected the anticipatory bail earlier. Not arrested till now.
Lordship.
We'll call for the CD. Fix it on an early date. Now, this aspect of the matter that there was an FIR against this particular person and the informant therein after getting bail in his cases lost this FIR against him.
Yes.
All this can be verified by at your level by the CD. Till such time since he has not been arrested till now. He cannot be taken into custody in case he appears before you. And if we find that there is some material against him, will we consider the decision?
Lordship.
Because now this is a new aspect which has come to us, which was not there in the other.
Yes.
Since he had incited incidents of money being collected,
Yes.
we were not inclined. We wanted the investigation to continue. This stage we are granting the interim. And that's it. What else you did? Heard Ms. So-and-so learned counsel looking for the petitioner, also heard the learned APT. The prayer for free arrest bail in this particular applicant had been rejected earlier by this court on 9/12/2025. The second bail petition has been, the second petition has now been filed. Again praying for the grant of the privilege of free arrest bail. Full stop. Call for the updated case diary.
Along with the lordship, say, CD Sunmari PS case number.
Call for the updated case diary of Sanmari PS case number.
Nagaon Police Station along with the Sunmari PS.
You give us one by one, madam, she has to write down. We'll ask for
Okay,
everything
diary
you
in
ask. Huh?
Nagaon PS case number 7.
Call for the updated, copy of the updated case diary in connection with Nagaon PS case number 762/2025. Corresponding to GR case number 2129/2025. And also
Sanmari
Sunmari
case.
PS case number
Sanmari
203.
PS case number
203.
203 of
2025.
2025. Stop. List again on.
Lordship, if Lordship grants them 7 weeks, 7 days time, then Lordship let it be on 16th.
On the 16th of February 2026. Full stop. In the interim, it is provided that in case the petitioner, no, that the petitioner shall appear before the investigating officer in Nagaon PS case number so and so on or before the
9th.
9th of February 2026. In the event of his arrest prior to 16/2/2026, the petitioner shall be released on furnishing a bail bond of, we'll put down the conditions, huh? We'll make it 15,000, on surety of the like amount. Appear before the IO as and when necessary. And call for not to leave the jurisdiction without prior information and intimation of the, to the concerned IO.
May I please, Your Lordship? Your Lordship, this matter was sent for mediation, Your Lordship, and the matter has been mediated, Your Lordship, as per the mediation report, which has been annexed at, as R, Your Lordship, prepared by the mediator on 25th of 2025, Your Lordship. We have agreed to the terms and settlements, and Your Lordship, I pray for disposal of this matter, Your Lordship, in terms of the mediations.
Who appears for the pension department? Who is the disbursing authority? The disbursing authority is whom, the State Bank?
The pension.
No. They have agreed that the disbursing authority will pay it into their accounts.
Yes,
Whether the disbursing authority was there present in the mediation.
Your Lordship, the treasury officer of Borpeta district.
Treasury
was-
officer does not pay, sir.
Yes, Your Lord.
Pension. Does the treasury officer pay you? No, the treasury
Yes,
officer
sir.
authorizes the bank
Yes, Your Lordship.
to pay you,
Yes, Your Lord.
to put it into your account. Is it
Yes.
not?
Yes, sir.
The bank is not there.
Yes.
49. And what about the department, the pension office? Someone has to give a direction to the. Ah.
It's number 7.
In favor of the,
First one.
now that is all done. Now with the mediation report, what has happened? First wife continues to receive. But you will face problems. Who is going to direct the bank?
Yes.
You agree that the bank will do it. Can the bank do it without a PPA?
Yes.
Without there being directions?
Yes. Yes.
Bank is not a party here.
Yes, Your Lordship.
Then.
Your
how to
Lordship,
bring
in
a-
this writ petition, Your Lordship, my only simple prayer before the honorable court, Your Lordship.
You have agreed for disbursal
Yes, Your Lordship.
into your individual accounts.
Yes, Your Lordship.
Who is the person to disburse? State Bank.
Yes, Your Lordship.
State Bank cannot do it without an authority
Yes, Your Lordship.
or an order from some person.
Yes, Your
It has to be from the treasury officer. It has to be from someone, the pension department.
Lordship. Yes, Your Lordship.
One PPO can only be issued. Then what happens?
Yes, Your Lordship.
Heard Mr. So-and-so Learned Counsel appearing for the
Lordship,
petition
then
also.
Lordship, stay order may be vacated, Lordship, otherwise they have not received pension, Lordship. And the first wife, Lordship, 86 years old now, Lordship. She's facing
Also
problem.
heard Mr. So-and-so Learned Counsel appearing for the respondent number.
Respondent number 7, Lordship, we have.
Respondent number 7, Mr. So-and-so appears. I'll give your name also, the conversation. See on a piece of paper. You have to appear on a piece of paper. Everybody. Stop, the matter was referred to mediation. The mediator's report is available in the records today, which was signed on 17/11/2025. Stop, as per the mediation, as per the agreement arrived at by the learned by the writ petitioner and the respondent number
7.
7,
First.
they have agreed to receive ₹4,000 only per month out of the total ₹11,249 by the, you are the first one,
First type.
by the petitioner, and the sum of ₹7,249 per month out of the 11,249 rupees per month for the respondent number
7.
stuff. They have agreed, the parties have also agreed that the concerned pension sanctioning / disbursing authority would effect the split payment directly into each of the parties' respective bank account every month in the above proportions, full stop. The pension disbursing authority, namely the State Bank of India in this present case, is not a party in the writ petition, and therefore this court, directs the petitioner and the respondent number 7 to appear before the competent authority disbursing the pension jointly and if required through their representatives to place before the disbursing authority a certified copy of this order along with the copy of the agreement arrived at between the two contesting parties so that the order, so that the agreement arrived at is given a fruitful conclusion. Full stop. List this matter again on 16th of February 2026 for the learned counsel for the respondent, for the petitioner and the respondent number 7 to apprise this court as to whether whether the agreement has been accepted and acted upon by the concerned disbursing authority. The parties would be at liberty to you don't read that part. You find out if anything more is required to be done. Tell us on the next day. If they require an order from the treasury officer or from the director of pension or anybody, then that order has to come, otherwise you are not getting anything.
Yes, sir.
But I am the
The interim order keeping and abeyance the disbursal of the monthly salary is vacated.
Your lordship, no need. I pray that this order maybe your lordship can.
No, then you will not be given the.
Yes, your lordship, yes, sir.
Lordship order.
Understand?
Yes,
Is
sir.
vacated only to facilitate the
Yes, sir.
disbursal of the pension as agreed to between both the contesting parties.
Yes.
A reconsideration will be given on the next date of proceeding. If
Stay order dated 25/6/2025. Order date, stay order.
you stay order को लिखेंगे, the interim order keeping in abeyance लिख लो, interim order passed on
25/6/2025.
Much obliged, your lordship.
16th of February. Let us know what happened.
Yes, much obliged.
Orders.
Content matter, on the last occasion, a copy of the compliance was submitted. Oh, I don't think they have exercised, in terms of honorable court's order, they have done.
What is the order?
Lordship had from page 26 to 29, my lord. Respond number 2, on receipt of representation shall hear all the 4 petitioners in person. After scrutinizing all the relevant materials and documents shall pass in appropriate order. And in accordance with law, within a period of 2 months from the date of receipt of such representation, till the representation is considered disposed of, responding to the report sent by the petitioner, so and so shall not be filled up. They have passed an order, it's of 17/7/2023.
Age?
No, lordship, this is a compliance report. They have given it to us yesterday.
Something here also.
Personally, we can look at it. Photo there, like. We also submitted before the,
Dated.
it's of 17/7. I don't know why it took so long, my lord, to produce the same, my lord.
We can allow this contempt to linger as long as you want, or we can try to find out whether it is
Yes.
contempt or not, or now since the reasons are on record before you.
Can file appropriate application. Oh, shit.
Learned counsel, heard Miss. Senior advocate, accepted by so and so, none appears for the continuance on call. Senior counsel. Hence report supplied to her on clear occasion
Great.
for the continuance. Stop, the Connect Senior Counsel has submitted that the aforesaid order does not appear to be in full compliance of this court, of the orders of this court passed on 27/7/2022 in WPC number 4755 of 2022. However, on going through the materials, this court is of the opinion that the spoken authorities have passed an order after due deliberation, stop, without commenting on the correctness or otherwise of the aforesaid order dated 17/7/2023. This court, as agreed to by the learned senior advocate for the petitioner, closes this contempt petition with the liberty to the petitioners to assail the order dated 17/7/2023 in such manner as may be available in law.
Lordship may kindly record the date on which it, 31/2026. We have received the same.
Yes, what did they say? On an earlier occasion, कुछ लागत सोचो?
Yes.
In your earlier occasion से on 31/2026. Earlier occasion to काटी दो 31/2026 को.
Hello.
A copy of the order dated 17/7/2023 is kept on record as X, marked as X. Yes. Disposed of. Hmm.
Lord,
The order says that Mr. B. Kaushik will produce the compliance report. Now, production of Mr. B. Kaushik is not here. Wait for some time. He might be in another court. B. Kaushik এটা দিয়ে দিবো।
Your Lordship, I'm not pressing this I applications.
What was this I for?
Your Lordship, withdrawal of the name of the petitioners, few of the petitioners. So your Lordship has on
It will
last.
create
I made them explain the things,
Hmm.
then they told me we'll wait for this.
Someone does not want to take the benefit of an order of this court, it's a different. Now, otherwise you'll have to come back to.
Yes, your Lordship.
Counsel appearing for Mr. R. Singhal and counsel appearing for the applicants.
Applicants. In-
Submits that he's under instructions not to press the interlocutory applications in their present form. Full stop. Accordingly, the interlocutory applications are closed as not pressed for the present.
Deeply
In the present form. Interim applications are disposed of. How many were there?
Two applications,
Two
3741 and 3745.
And anything to be done on the repetition? They have to fix a date, something?
Yes, your lordship, may fix a date for a hearing.
Are the pleadings complete, sir?
Yes, your lordship. It is in the admission, otherwise it's whenever it's.
Can we take it up for,
Yes,
disposal
it's
on
on here.
some fixed date? Give us a date, sir. Give us a date. Convenient date.
Let it come up on 26th of February, your lordship.
26th of February. 26th February. The repetition is this matters on 26th of February. Learned councils are requested to prepare for a disposal.
Deeply. Matter related to the. Putting up, with the petitioners. Petitioners are the members of the Indian Oil Corporation Limited. ISO Bongaigaon Refinery, BGR Township Maintenance Electrical Workers Association. Those workers, they have been engaged by the response number 4. Response number 4. MS Dhaligaon Unemployed Youth Labor and Allied Industries Asia Cooperative Society Limited, given by a contractor association. Those contractors have engaged the petitioners in the Bongaigaon Township electrical maintenance work. They have been engaged to do work for the refinery, but the refinery has not engaged them directly. Through the contractor, they have been engaged. The payment has been made by the refinery through the contractor, not directly, just to avoid the direct relationship between employer and employee. So they have been, the petitioners, they are equally qualified with that those who have been engaged by the refinery for doing the regular work, my lord. So they have been making application to the refinery for regulation of their work, my lord. But it was not done for last, they have been working since 1981. Thereafter, the petitioners, by forming an association under the name and style of employers, Unemployed Youth Association, had made an applications to the response number 2. The labor, State Labor Commission, I may be allowed to read out the first synopsis of the case.
Is it a registered association?
Hello?
Is it a registered association?
Yes,
Where do you find it?
association, they have. I may be. The forms are within the MLA. It is registered with us, not filed. But here, my lord, basically, they had made here is very simple, my lord. They had made an application to the labor inspector or assistant labor commissioner, number 2, to look after the matter by conciliations. If the conciliation fails, the matter may be referred to the appropriate government to verify to whether there is an industrial dispute or not. If there is an industrial dispute, then matter may be referred to the, my lord, necessary.
Yes, what do you say? There is an industrial dispute or not?
No, Lordship,
There is no industrial dispute.
because Lordship for industrial dispute,
Ah,
there should be relation between the employer and the employee.
yes.
And they are employed by the contractors,
Mm.
not by the principal employer or the BGR corporations. Lordship, we have actually, Lordship, IOCL BGR is refinery is engaged in the main business of manufacture and productions of essential petroleum products.
Mm.
The core operational functions of the refinery are discharged exclusively by regular employees of the corporations, and the work in questions pertains only to non-core activities.
You
With
said
a-
it is a registered association. Did you say it was a registered association?
Maybe without the first of the.
Yes,
Registration certificate is not 5 years, but it may be.
it's a non-registered association.
That the petitioner association, petitioner is mainly Indian Oil Corporation Limited. Limited Bongaigaon Refinery, Township Maintenance Electrical Workers Association, we call the so and so is a non-registered, non-registered compromise, non-registered association, compromise of all these employees engaged by.
So it is a non-registered association.
My lord, they are not seeking anything directly from their peer is that. They have
Show us some law that we can entertain a writ petition by a non-registered association of persons. We'll come back in 5 minutes. Have a judgment ready, we'll go into the other aspect of the matter.
and to take instructions so that they.
Take it within the next 5 minutes. It is 2014,
Take inspection from them.
when?
But generally it is written here that it is non-registered,
Matter ends,
non-registered association.
matter ends.
So non-registered association, they can file an.
We'll give the
application to-
liberty to each of the
No,
each of the
directly-
other.
Directly, they do not seek any benefit from the industry, my lord. Bongaigaon Refinery, my lord. They are filing an application.
Locus standi, jurisdiction, the delay and latches or something, the
May be
maintainability.
done, but when all the employees are signatories, because all members of the association are signatories here. So it is not filed by the president or secretary to be registered, but filed by all the members, my lord. They can jointly file it, my lord. No registration is required, my lord. There is very simple, my
Lordship,
lord. When I make an application to the labor authority, the response number two, to verify whether after receiving of the application from the.
Yes,
petitioner,
Judgment.
Lordship, there is a
Give us a
registered.
judgment.
Yes, Lordship, I have.
It is not filed by any, it is not signed by any of the president or secretary.
not
Kindly go through page 13.
all.
We'll come back in 5 minutes.
Lordship, BRPL has registered labor union, but
Huh?
BRPL has registered trade union, but the petitioners are not members.
Hmm.
Lordship.
Where is the judgment, unregistered association?
So, I will be allowed to read the para one.
I'll come back, just give me.
What done? They have filed the president. Appoint the president to file this case and they have also
Where is it?
the police.
Where is the authority?
Case 7, para one of the petition. But the
Para one is something which he has one. What's the
The
authority?
petition association, namely India Oil Corporation Limited, IOCL, Bongaigaon Refinery, BGI Township Maintenance, Electrical Worker Association, we told the IOCL BGI 7 is a non-registered association comprising of all these employees engaged by the Indian Oil Corporation. Bongaigaon Refinery, we call as BGI in after. The respondent number 3 for the works of the electrical maintenance in the BGI Township to MS Khaligaon Employee Association. Respondent number 2, Bongaigaon Refinery have engagement for the respondent number 4. The Unemployed Youth Labor Association and the Cooperative Society Limited. The respondent number 4, since the year 1991, and all the members of the association have empowered and authorized its president, Shri Vishwanath Bosumukari, to represent the association in the instant writ petition and or any other litigation in respect of the association by the resolution dated 11/9/2012, adopted in the general body meeting of the state associations on the same day, and as such, it is entitled to all the rights, privileges, and protections granted under the Constitution of India and the laws and thereby. So Annexure 1 is the resolution adopted by the committee. Annexure 1, my lord.
What is the name of your association?
Association
What is the name of your association?
Yes, I think. There are one it is mentioned, name of the association is my lord, Bongaigaon Refinery Township Maintenance Electrical Workers Association. There are one of the petition. There's a petition, right?
Bongaigaon?
Bongaigaon Refinery is the Bongaigaon Refinery Township, Bongaigaon Limited, Bongaigaon Refinery Township Maintenance Electrical Workers Association. Be called as
Okay.
IOCL, a non-registered association. This is
Not in the present form, sir.
non-registered association.
It will not be in the present form because the Wakalatnama is signed only by the president, so-called president.
Not
The
really by-
affidavit is only by the president. There is no letter of authority by any of the other so-called members, unregistered association. We will grant you the liberty to approach each of the alleged members of the association.
Most of them have died and left us.
Then why are we pursuing this petition?
21, my lord.
How can we then?
So you will see kind of see the resolution, Annexure 1. That is not the three in the WS also, that the petition is not mandatory for the decision. That is not the three.
What Mr. K. Sharma, learned counsel appearing for the petitioners also heard. Miss R.
Kakoti,
Learned counsel appearing for the
respondent number 3.
the rest of
Responding
the
counsel,
respondents
yeah.
are not represented by their counsels today in the court. Please stop. Drawing our attention, and this court has noticed that the petitioner association, namely Indian Oil Corporation Limited, Bongaigaon Refinery Township Maintenance Electrical Workers Association, is a non-registered association. Stop. The affidavit has been sworn by the president of the said association. The Federal Council has referred to the resolution dated 11/9/2012, taken in the general meeting of the association to impress upon this court that the writ petition is maintainable, despite the fact that the petitioner is an unregistered association. Full stop. We have also gone through the Wakalatnama. The same has been signed only by the so-called president of the association. Full stop. There are 29 signatures on the resolution referred to by the learned counsel. Look up the top. This court, in view of the settled position of law, that unregistered, that a repetition by an unregistered association that informer is unable to continue to entertain this petition, full stop. Accordingly, this petition is closed in its present form, granting liberty to any to the members of the so-called association to approach appropriate forum of law in accordance, appropriate forum in accordance with law, with any grievances that they may have regarding their contention for being regularized into the services of the IOCL. The petition is accordingly closed. We are giving you the liberty approach in a proper manner. We may entertain it. But not in this form. This will lay down the long run. Huh?
I think the most of them of the employees since 1991, they have retired, died and left there. What are
These facts are not before the court also.
time to obtain.
Therefore, we need a registered association who can carry on the cause.
Mine is not that they
This is
have
item
not sought
number?
anything directly from the refinery. They simply file the application before the labor authority.
Ah.
Labor authority will have to make an
Sir,
consideration.
if we go into that, the Labor Commissioner says that the subject matter is not within the Industrial Tribunals Act.
But labor commissioner has not replied in that way, my lord. Labor commissioner has referred to the refinery. Refinery says that we cannot raise it.
We have
The
closed the,
question of registration has not
we
been
have
asked by
closed
your
the
court.
writ petition. We have not commented upon the merits of anything. You can bring in this affidavit in opposition in the next writ petition to say that, look, it was not even negated. You have your claim, is it not? But not in the form in which one cannot entertain it.
But that point has not been raised by the other side in the affidavit also.
Came to our
It
notice.
does not make any-
It came to our notice,
It
unfortunately.
is not expressed.
Unfortunately, it came to our notice. Yes, item 15. You are seeking some time. What is the matter about?
If the matter pertains to compulsory retirement, Lordship.
When do you want it? Yes, sir, madam. When do you want it?
2 weeks, Lordship.
2 weeks.
Yes.
At the request of the learned counsel for the respondent and the consent of the learned counsel for the petitioner, list this matter again on 24th of February 2026. Full stop, the matter is of 2016 and therefore a attempt would be made to dispose of the same on the next data. What was your age when you read? 58. How many years of service was left? What is the date of retirement in the bank? 16, so 2 years. Compulsory retirement with all benefit, all retirement benefit. Yes, madam, you have to tell us what is this process of imposing different penalties on different charges?
Sure, I have not prepared.
You have to be prepared. You are taking up 3 charges. 1 charge, compulsory retirement. Charge number 2, reduction in pay. You have already compulsorily retired him. What do you reduce in pay then? Eh?
Much obliged, Lordship.
Yes, sir.
Matter concerns with, my lord, concerns with inequality in the scale of pay concerning IIT Guwahati and corresponding to the other IITs actually, primarily IIT Guwahati. For concerning the this non-teaching staff, primarily technicians. We are the technicians. There were schemes introduced by the authority for the welfare and career progression of the staff. Accordingly, the scale of pay parity is not matched accordingly to other. It's a single scheme which governs the entire actually IITs.
So they are also technicians in IIT.
Yes.
There are other technicians in other IIT.
Yes.
The
They are
scale of
getting
pay is not being given
according
equal.
to the scheme. One scheme is the RCPS.
What
according
is the RCPS full form?
It is your lordship, career
Recruitment
progression.
and career progression scheme.
Yes,
So that is almost like the ACP,
almost like that, your lordship.
Assured Career Progression
Yes,
Scheme. That
it governs
yes.
the, it is governed by the.
So
HR.
while other technicians in other IITs get a better upgradation, you are not getting that
Yeah,
upgrade.
according to the pay commissions.
In your case, what has been done?
What happened, your lordship? We are appointed in the intermediate stage. intermediate stage as technicians.
Huh.
When the RCPS was introduced, our scale of pay was, we are demoted, almost like a demotion, to the junior assistant scale of pay. Whereas in the RCPS itself is mentioned as particular scale of pay is
Go up.
paid.
It has to remain the same or go up.
Yes, yes, according to the other IITs, because it governs the entire IITs together, except IIT Roorkee. So we,
IIT Roorkee is having the same as you.
no, we are part of the other IITs, barring IIT Roorkee, it is mentioned in the RCPS.
Okay.
My senior, my senior counselors, counselor,
No, you have done good enough to make us understand what your case is.
how to
You just need to have a reply.
allow me to go through.
Definitely. But then with their non-representation, can we proceed, sir?
I have a. Let a date be fixed. For final.
This is item 16. Till now, they have not corrected this skill.
They tried,
That you are asking for parity with the other IITs. Do you have any case law with you? To show that yes, between the IITs, the technicians, their since their qualifications, entry-level qualification is the same, the nature of the work executed is the same.
I have filed an affidavit in reply, it is there, an additional affidavit is
No,
also.
that is, those are your statements or your arguments.
No,
Have to
I
be
have-
supported by something.
I have brought annexes.
What annexes have you brought?
For example, Your Lordship. Right now, Your Lordship, humble submission, Your Lordship. Right now, we are paid according to the scale of pay we are entitled to actually, but through promotion to the senior, because it was redesignated. It is not there in the scheme itself, but now what our prayer is, Your Lordship, if we go through according to that, then our area salary and the consequential benefits which we avail, I will make submission. Because the other side is not there.
Support your,
I have placed.
support your assertions by some citations, also some judgments. It will
Yes.
help us.
Yeah, previous writ petitions were already filed, Your Lordships. In comparisons to two employees of IIT Mumbai, we have produced, we have placed the affidavit in reply also. Through RTI, we have availed such type of document.
You are Mr.
My name is A. Narzari, Your Lordship.
A. Nazari, heard Mr. A. Nazari, Learned Counsel appearing for the petitioner. The Learned Counsel for the petitioner has made preliminary submissions on the writ petition, full stop. However, none appears for the respondent IIT today, and therefore the matter could not be taken up for disposal. Full stop. Place this matter again on. Choose a date, your convenience.
Permission manual regarding item number 34, we got message posting in the Arunachal Pradesh.
We'll take it up. We are in the midst of another matter, madam. Give us some time. Do not intervene in the matter itself. Take it up. Choose a date.
Last week of February, Your Lordship.
Last week of February, T date, 26.
On any hearing date, last
On 26th of February 2026.
oblige, Your Lordship.
It is made clear that in the absence of any representation from the respondents, the matter will be taken up for consideration.
Oblige, Your Lordship.
26th of February.
Met with the Lordship. This matter relates to discharge of service of the petitioner by way of a departmental proceeding. In fact, Your Lordship, you were at the lowest rank as a constable in 1995. In 1990, he was appointed as a constable. In 95, there was a theft in a Malkana.
In order to find out its scapegoat, they have made this constable responsible for this. And they have carried out a disciplinary proceeding behind his back and ultimately dismissed him from
So
service.
the first ground is scapegoat.
Scapegoat, Your Lordship. And then secondly, in the disciplinary proceeding, he was not made any aware about the disciplinary proceeding. No cross-examination was done on the basis of statement of the senior police officers, Your Lordship. He
Right.
has been dismissed from service.
What was stolen?
Lordship.
What was stolen?
Total, some things from the Malkana, Your Lordship. That was the case, Your Lordship. May I place it? He was appointed on 1990. 19th of September 1990 as a constable, Your Lordship. In 1995, Your Lordship, one theft was committed in the court Malkhana, Your Lordship. As a result of which, Your Lordship, in this case, he was placed under suspension, Your Lordship. At page 14 is the suspension order. On 3/1/1996, he was placed under suspension. Page 14, Lordship, at 14.
What is a veteran criminal?
They said that I have relation with some criminal and therefore
Veteran criminal.
veteran criminal. And that veteran criminal came and deposed before the disciplinary proceeding also.
Saying what? He knows you.
He knows you and all this, particularly veteran criminal. He's not afraid of police, but he's also coming and.
What is his name?
Lordship, Sirajul Haqla, sir. Constable Sirajul Haqla.
No, the veteran.
Abdul Wadud.
Huh?
Abdul Wadud.
Abdul
Wadud.
Adud. He is not there in the list of witnesses.
But in the statement, I have found that he
He is not there in the list of witnesses.
Now, page 16, Lordship, they have issued a show cause notice, Your Lordship.
Yes.
Page 16, and they have given 5 allegations against me, Lordship. Goes to it. Number 1, Lordship would find who frequently visited the house of veteran criminal Mr. Abdul Adud, and he also visited your house frequently. On 24/12/1995 evening, he is present in your house along with Habildar Sir. Second one, on 26/12/1995 evening, you along with Tamijuddin Lasur went to so and so area with 2 hired market, and thereafter, along with Tamijuddin Lasur, you visited Baba Hotel at about 12 hours midnight. Number 3, you went to Asingan Silchar without any leave or permission from the competent authority by hiring Marti Pen along with veteran criminal Abdul Adud also. Number 4, on 30/12/1995, incriminating documents articles were recovered from your house, which you kept unauthorizedly. And number 5, you handed over your personal jacket to veteran criminal Abdul Adud, which was recovered from Abdul Adud during his apprehension. Then these are statement of allegation at page number 17, the same thing, and then witness to be examined. Some 10 witnesses have been named who are to be examined, Your Lordship. Most of them are police officers, Your Lordship. Documents and articles that were seized given at page 18. Like a pair of shoulder belts of ASI jacket, some intelligence jacket, some command certificate, these things were the documents and articles to be exhibited. 1 warrant, summons, 1 final report, and all these things, Your Lordship. So we made a reply, Your Lordship, at page number 19.
Yes, madam.
That everything
No,
was
page 32.
Lordship.
Page
Remain on
32.
Lordship.
Based on the findings
Lordship,
of inquiry, it has been proposed to award him
Lordship.
major punishment.
I already have.
Even
that.
before he has the inquiry report, I'll give you major punishment.
That I already have noted, Lordship.
What to do? Because if we go into the merit of it, there'll be a problem.
Lordship.
We'll have to say, yes, we find him, or yes, we do not find him. The printer is not effective enough in making a curtain. Yes,
This is the main thing, Lordship.
if we go deeper into it. Hmm?
As per record, Lordship, he was present all along, Lordship.
Could be, but the formality that requires
That
to be done
Lordship.
cannot be said to be an
Yes, Lordship.
informal formality, inadequate formality, let us say. We cannot have it as an IWAS. So he made an appeal, he did everything, What was this earlier order? In the appeal, why did the appeal try to find out the other witnesses?
They already have retired, Lordship.
No. Why did the appeal try to go find out the other witnesses?
Yes,
Was it
Lordship.
necessary?
This is their Lordship, that I have said.
You were acquitted.
Yes, they have also filed a case of Arms Act, but in the Arms Act, nothing was found against me. Acquittal order.
And the lower court did not find you involved in the incident, or did it find you involved in the incident?
No, that was a separate.
The allegation against you was only on the Arms Act.
That I had kept some unauthorized arms, but there was nothing in law. Even those seizure witnesses, they said that they don't know anything about the seizure. All the seizure witnesses said that we don't know, police came and put our signatures.
Ah,
Only after 5 years of serving.
what was the allegation that you were in touch with a
Veteran criminal law.
veteran criminal?
I visited, I
And
was Mongari with him and they have,
but you are a police officer. You are
Yes.
supposed to be in touch with veteran criminals so that they don't do anything more, any more mischief. You visited hotel without any leave. You handed over a jacket to the
all allegations.
yes.
Lordship may kindly take it up day after tomorrow, Lordship. I also will go through this, Lordship, and Lordship may finally dispose it for me.
The earlier order of this court required you to give him an ample opportunity by giving him a second show cause notice.
Yes, Lordship.
There are judgments of this court
Yes, Lordship.
which says that a second show cause notice cannot be a predetermined.
Predetermined. Yes, Lordship.
The notice,
That
the
I'm
language
already
in which it is
with
given
Lordship.
is a predetermined notice.
Yes, Lordship.
In those cases, we have given the liberty to
That means
drop it,
restart Lordship from that
start
stage,
again at the
Lordship.
stage of the second show cause
Yes,
notice,
Lordship.
and then do whatever is required.
But here I think there is no possibility, Lordship. I think by this time if he was in
Yes.
service, Lordship, he would have retired, Lordship, by this time.
Huh?
In some years.
They will pass all the some years in deciding the second show cause.
Second.
47 in 2000,
Very difficult to fight.
17.
State.
57, 56, 4 years.
4 years. period.
Hmm?
Some 3-4 years. period.
But otherwise, the decision has to go. It
Lordship.
has to go before, and I think the officer would not also be there now.
How would you do
So
that?
the predetermined mind would not be
Yes,
there.
Lord.
The second show cause notice giving him an ample opportunity.
Oh, Lordship, may pass an order like
Huh?
this, Lordship.
Otherwise, we will
Otherwise,
enter into
yes,
any other
Lordship.
part of-
I totally agree, Lordship.
Heard Mr. M.H. Laskal and Council appearing for the petitioner.
As service
heard-
remains, Lordship.
Huh?
As service remains, Lordship, may pass this
Ah.
order, Lordship.
You can take a,
Yes, Lordship.
also heard Ms. Bhattacharjee, senior, additional senior government advocate. The challenge in this writ petition is to the order dated. Which order?
All the orders are not coming.
And the,
No,
yes,
no, no.
Lordship, the order of dismiss.
The order dated 16/8/2016, by which the appeal of the petitioner filed before the Deputy Inspector General of Police, Assam Silchar, had been rejected by upholding the order dated 17/4/2000 14, discharging the petitioner from his service. Full stop. The order dated 17/4/2014 is also the subject matter of this writ. The facts in brief leading to the passing of the impugned order dated 17/4/2014 can be traced back to a show cause notice issued upon the petitioner on 10/2/1996 in DP case number 2 of 1996 by the Superintendent of Police Karimganj, leveling 5 charges against the petitioner. Full stop. On the basis of the 5 charges, the petitioner was required to submit his statement in defense within 10 days from the date of receipt of the communication provided to him. Full stop. The statement of allegations was also appended to the said show cause notice. Full stop. A list of 10 witnesses and the documents and articles to be exhibit were also given to the petitioner. Instead, the petitioner gave his reply
26/1990.
on 26/1996 and thereafter by an order dated 29/11/1997. The Superintendent of Police Karimganj discharged the petitioner from service with immediate effect. Pertinent to note here, as pointed out by the learned counsel for the petitioner, that the petitioner had joined his services on
19/9/1990
19/9/1990
as constable
as a constable,
in Assam Police.
being aggrieved by the order dated 29/11/1997, the petitioner had approached this court by filing WPC 6/289 of 2006, whereby an order dated 12/12/2013, the impugned order
Page 28.
the impugned discharge order was quashed. The petitioner was permitted to give representation against the inquiry proceeding, and if such representation is filed, the disciplinary authority would consider the same on merit by taking note of the petitioner's grievances. It was further observed in the order passed by this court that the petitioner would not be reinstated in service automatically, since the interference with the discharge order was being made by the court only on consideration of breach of principles of natural justice. Stop. The petitioner thereafter served and therefore filed a representation to the Superintendent of Police, Karimganj. Full stop. The Superintendent of Police, by a communication dated 15/3/2014, served the second show cause notice, thereby supplying a copy of the inquiry report and a certified copy of the departmental proceeding inquiry report to the petitioner, requiring him to file a reply to the second show cause notice within 10 days of receipt of the same. Full stop. The petitioner replied to the aforesaid show cause notice by which he plead that he prayed for a reinstatement.
Stated that he was not allowed to participate in
Eh?
the proceeding. Paragraph 5, page 51.
Ah,
Stated that he was not allowed to participate in
the
the proceeding.
petitioner had submitted that he was not allowed to cross-examine any of the witnesses during the inquiry proceedings, and that the inquiry officer had acted perfunctorily. Full stop. After a consideration of the reply filed by an order dated 17/4/2014, comma, which is a subject matter of which is a subject matter in this petition, comma, the petitioner was discharged from his services again for his criminal activities, full stop. However, no orders were passed with regard to the interregnum, with the interim period which had passed between the date of the original order, comma, the date of the High Court having quashed the earlier proceeding, and the date of the passing of the order against the petitioner, full stop. The petitioner had thereafter filed another writ petition registered as WPC 3680 of 2014, which came to be disposed of on 22/4/2015, requiring the petitioner to file an appeal against the discharge order as provided for in Rule 13 of the Assam Services, within bracket Discipline and Appeal Rules 1964, within a period of a month from the date of passing of the order, full stop. The petitioner preferred an appeal dated 7/5/2015, which came to be rejected on 16th of August 2016. Next paragraph, the learned counsel appealing for the petitioner, Mr. has submitted that the appeal, that the order passed by the appellate authority would demonstrate that the appellate authority had tried to communicate with the witnesses mentioned in the disciplinary proceeding. However, none of the witnesses could be traced out except one. No, however, except one, comma, none of the other witnesses could be traced out to corroborate the earlier statements made in the PP. The appellate authority had found that there was a lapse of almost 20 years, and therefore all the police personnel had already retired. The appellate authority had definitely come to a finding that, the learned counsel, Mr. Lashkar, submits that although it is apparent from the order passed by the appellate authority that the appellate authority had come to a finding that the statement of the witnesses carried their signature, comma, the order does not reflect any finding on the fact as to whether the writ petitioner had been allowed an opportunity of cross-examination by the during the inquiry proceedings, full stop. He has further emphasized on the acquittal granted to him by the in the criminal court to prove that the appellate authority could not have relied upon the principles of preponderance of probability to dismiss the appeal filed by the petitioner. Full stop, next paragraph. Mr. M.H. Loskar has also referred to the order dated to the show cause notice dated 17. No. Show cause notice dated.
10 to 9.
Huh?
10 to 9. Second show.
Second show cause
15/3/14.
15/3/2014 to impress upon this court that the very language would demonstrate that even before deciding to supply a copy of the inquiry report to the petitioner hearing, the disciplinary authority had required him to, had noted that based on the findings of the inquiry, it was already proposed to award a major punishment of dismissal from service upon the petitioner. The learned counsel for the petitioner has submitted that the disciplinary authority, having already framed its mind regarding the guilt of the petitioner while issuing him the second show cause notice, the supply of the inquiry report to the petitioner, and also the so-called second show cause notice, giving him a purported opportunity of controverting the findings of the inquiry report. Full stop. What is the sentence? How did I start it? The learned counsel also submits that. Controverting the findings in the inquiry report were made as a mere formality and did not give an effective opportunity of defense to the petitioner. Full stop. In such view of the matter, he praised that the impugned order dated 17/4/2000 be set aside and quashed. Full stop. He further praised that the second show cause notice not, since the second show cause notice does not reflect that it was done with a impartial mind, the same also deserves interference of this court. Full stop. We'll come back and do step 2 and finish it off.
So I have one fixed matter now.
No difficulty. We'll record your submissions that you have vehemently opposed. He had all the opportunities and he did not make a proper. All the opportunities and he did not make a proper representation, for which the disciplinary proceeding culminated in the manner that it has now been prosecuted before this court.
Regarding 34, I think another date may be fixed, my lord.
Which one?
As 34 contempt case, Mr. Kaushik, he is in Itanagar bench. Mr. Dhar received no message, my lord. 34 contempt. Supply list. He knows very well. This is today also. Today I have filed our vocal number for
Yep.
number 1.
Has the correction been made? A simple thing.
And no, my lord, 2% has claimed for the benefit, my lord.
Okay. Learned counsel appearing for the respondent number 2 has submitted that their instruction.
My
One,
lord, we
one.
go see.
Appearing to the respondent number 1 has submitted that she has received instructions justifying the delay in complying with the orders of this court. Full stop. She accordingly placed that she may be granted the opportunity to file an affidavit. Place this matter again on 16th of February 2026, by which date the respondent number 1 and 2 shall respond to the allegations made in the contempt petition by way of filing affidavits. Full stop. In the absence of affidavits, the court may be constrained to pass.
Item number 9.
Yes, we'll take it up at 2. You don't want it
Planet
to-
age is 2 o'clock.
Okay.
No, no, at 2 o'clock I'm ready, my lord.
Special bench we have to accommodate.
Number 3.
Special bench we have to accommodate.
Then tomorrow, my lord, it is possible tomorrow.
Tomorrow is a motion day, sir. The list is already out.
Then Saturday, my lord. Friday, my lord.
Friday is again a motion day. Take Thursday, fifth,
Pardon, my lord.
Thursday.
Thursday.
Huh?
Thursday, yes. Sir. Thursday, yes. Sir.
It's a good day.
Yes,
Good day.
Deeply obliged, my lord.
At the request of the learned council, appealing for the parties, list this matter again on the
But
5th.
Lanet AG should be present, my lord. I request him to be present that day.
Oh, we can pass orders to authorities, sir, not to councils. Cannot do that.
Deeply
How can I enforce him to come here? Thank you. Per contra. It's in Bhattacharya, Thane Council. Thane Additional Senior Government Advocate has submitted that the petitioner had been given all opportunities to defend himself during the departmental proceedings. And he has also been given a copy of the inquiry report, to which he has filed a detailed representation after the matter had been remanded back by this court. The learned council has also submitted that the appeal referred by the petitioner had taken up all possible grounds, and every ground had been addressed by the appellate authority while rejecting the appeal. Laptop the learned council has further submitted that the petitioner had joined the services in the year 1990 and had been terminated in the year 1996, and the matter being such an old matter, no fruitful relief can be granted to the petitioner at this stage, since even though the litigations continued with regard to the impugned termination of service. Full stop. We have given due consideration to the submissions made, and also we have also perused the records made available to us. Do you have a copy? Do you have the departmental inquiry records?
Yeah,
No, the records are here, na?
records are here. And
This
he
is
has
the so-called
cross-examined also some witnesses, Lord.
some witnesses.
Yes,
We
Lordship.
will not go into all this.
Yes, Lordship.
The second show cause notice, this is the one which is available.
Yes, Lordship.
The records reveal that the second show cause notice as annexed to the writ petition was in fact the notice which was served upon the petitioner after this court had directed the same to be done by its order dated 12/12/2013. The second show cause notice the relevant portion of the second show cause notice is quoted herein below. It does appears to this court that the superintendent of police, Karimganj, who was also the disciplinary authority of the petitioner, had agreed to the findings of the inquiry report and had made up its mind to propose to award a major punishment of dismissal from service. This court feels so because the question of the quantum of punishment to be imposed upon a delinquent would arise only once the disciplinary authority was convinced with the findings in the inquiry report. Full stop. This court notices that such a finding had been arrived at by the disciplinary authority even before the petitioner had been given the opportunity to have his say on the inquiry report. Full stop. This court, in the case of Babul Hussain versus State of Assam and others, reported in 2024 1 GLT 51, had held as follows. Paragraph 13. You take down this. Paragraph 13. Paragraph 21, 22. Twenty-four. This court also notices that the punishment, the penalty, not the punishment, say the penalty imposed upon the petitioner is one of discharge from service, which is not a prescribed penalty. Stop. With regard to imposition of discharge from service as a penalty upon a incumbent who was serving in the Assam Police, this court, in the case of Babul Hussain Supra, has held as follows. Paragraph 25. This court notices that the facts involved in the case of Babul Hussain versus State of Assam Supra were very familiar with the facts of the present case insofar as they relate to the challenge to the disciplinary proceeding. Full stop. In the aforesaid case, as has been done in this case, the allegation of absence of opportunity of cross-examination of the witnesses in the inquiry has also been taken. Full stop. Next. While humbly agreeing with the law laid down by this court in Babul Hussain versus State of Assam and others, this I am of the considered opinion that the petitioner suffered, that the process and method adopted by the disciplinary authority in coming to a conclusion of guilt of the petitioner, as has been done in the present case, cannot find the support of law and reason, and therefore the impugned show cause notice dated 15/3/2014 and all action taken by the disciplinary authority and the appellate authority consequent to such show cause notice deserve the interference of this court. Accordingly, the show cause notice dated 15/3/2014, the impugned order of discharge dated 17/4/2014, and the appellate order dated 16 August 2016 are set aside and quashed. On the setting aside of the proceedings after 15/3/2014, the petitioner would now be entitled to be reinstated in service. The petitioner would now be reinstated in service, full stop. The respondents would be at liberty to issue a fresh show cause notice to the press, second show cause notice to the petitioner, if it is so deemed necessary, to continue with the departmental proceedings that had been initiated against the petitioner in the year 1996, and when the appellate authority in the appellate order had himself come to a conclusion that none of the witnesses would now be available for proceeding or for giving any would now not be available, full stop. It is noticed that the petitioner has been kept out of service, not on his own volition, but due to an order which requires the interference of this court. But it is also noticed that the orders, but that the show cause notice and the consequential orders have been interfered with by this court only because of the violation of principles of natural justice. In such circumstances, it is ordered that the petitioner would be deemed to have continued in service. However, there would be no entitlement to his back wages. Full stop. It is also provided that in case the departmental authorities deem it fit to proceed against the petitioner, the second show cause notice shall be served within a period of 1 month of the petitioner reporting for duty, and the departmental proceedings shall be concluded as early as possible if started, and in any case not beyond a period of 3 months from the date of the petitioner reporting back on service, full stop. Accordingly, the repetition stands allowed, no costs. The departmental counsel is permitted to return the records in original if any requisition by, as requisition by her. Yes.
One line may be read.
Hmm.
In case the departmental proceeding is not taken again, it may be reinstated.
I have said that if they want to continue the departmental proceeding, they will do so within a period of 1 month of your reporting for duty. If they do give you a second show cause notice, it has to be concluded within a period of 3 months from the date of your reporting on duty. So if they continue after 3 months, 1 day, please come down, we'll strike a batch. We cannot deny them that. Because you see, on the first occasion itself, this court said that it is only on grounds of principle of natural justice and we have to give them the liberty. We cannot take that away.
Indication is that in case the department does not want to proceed, he may be immediately reinstated. Because it is not there.
This court has not given any opinion as to, has not expressed any views as to whether the department is required to proceed against the petitioner in the past department proceeding.
I'm deeply obliged.
You should take an order when it comes. Already I have observed that the appellate authority has said there is no witnesses.
Yes, yes.
It is an old matter, this and that. You should, the moment I say I am not expressing an opinion, the liberty is utilized to the fullest.
Obliged.
Yes. সেইটো টাইম দিলি ন পৰহি দিলি ন সেইটো 5 টকা এটা আছিল যে 3 টা 4 টা একেলগে আছিলে আকেৰি চৌধুৰী হা ডেপুটি এছিও Yes, yes.
The matter may be listed after, day after tomorrow.
So you started with may I please, and this court is not pleased when you ask for a date. What is the matter about?
This petition
Matter of 2017.
17.
Why should we allow you time? Just a minute. Where is the dismissal order, madam?
Dismissal order is at page 11, Lordship, Annexure A.
What happened to the police cases?
Lordship, police cases,
I think there's an order requiring you to come up with the instruction as to what has happened to them.
Your Lordship, we have as far back as on 23/7/25, Lordship, we had communicated with the respondent authorities to
Tell us that,
to
madam.
furnish us the records.
We'll have to hold the respondent authorities responsible for not complying with their orders. You should not only inform the court, you should also know how to inform the court.
Lordship, we have
Have you
also
filed the
filed
contract?
our affidavit, Lordship.
You file an affidavit.
Yes, Lordship.
Okay, just a minute. Yes, madam, start marking. Do you have the file with you?
Yes.
You will have to do the case. There's no one else. Yes, sir.
On behalf of S.A. Ahmed, she is.
Why don't you assist her to to perform something in the court? If you want to assist her in performing in the court. Don't assist anyone to run away from the court. This is a career she has chosen. Did not? You want to do the case? Yes. So let us try. Open your file, we'll go page wise. Try and understand what we are talking about. Okay. Just try, find out, let us find. Yes, madam.
Lordship.
The charge sheet, where is it? Have you placed it on record?
Yes.
The charges in the disciplinary proceeding.
No, Lordship, that is what, only the dismissal order, the
Hmm.
FIR and the charge sheet in the criminal case have been annexed to the writ
Where is
petition.
your affidavit?
Our affidavit, Lordship, is
Yes.
being filed on behalf of the respondent number 2, 3, and 4, Lordship. There we have stated,
Yes, ma'am.
Lordship, that the petitioner was given ample opportunity to defend his case, Lordship, but he was unable to do that. And in the dismissal order also, Lordship, it is an admitted fact by the petitioner himself, Lordship, that he was involved in criminal activities. Being a police personnel, Lordship, of the
What is the activity?
Lordship here, paragraph 4, Lordship, of the affidavit filed by the state respondents. The petitioner was initially appointed as constable
Paragraph
4, Lordship,
of?
of our affidavit, Lordship.
Just a minute.
And the incident, Lordship, is at,
Have you read the FIR page 13?
yes, Lordship, page 13 is the FIR.
We were only, we were feeling the manner in which it has been translated. They will publish them in the media and they will also slap and below me bhusa. Your affidavit. We have an affidavit in reply. We have an additional affidavit. Where is the affidavit in opposition? 2 to 28. What did you say in your affidavit? There are four.
Four is that lordship, an earlier DPO was also pending, disposed of. The petitioner was initially appointed as constable and he joined in so-and-so on 1996. On completion of the training, he was posted at 2nd AP Battalion, Makum, and thereafter at Commando so-and-so Guwahati. On 23/9/2009, the petitioner had joined Sibsagar as Constable UB. It is a fact that his indisciplined conduct was recorded in his service sheet after initiation of a departmental proceeding by DP number 8 of 2004. Subsequently, the DP was disposed of, dated 4/5/2005, with an award of punishment of stoppage of 1 increment for 1 year, with retrospective effect for his indisciplined conduct.
We do not know the charges as of date. What is the charge against him in the DP?
This was the earlier DP lordship. Later on, he was again filed
I'm not
after this
that-
FIR was filed.
He was exonerated, then there were 2 FIRs, both the FIRs ended in a final report without there being any charge sheet. Are we reading correctly? Para 4, last 2 lines. Both the cases were returned in FR as the cases to insufficient evidence. So the cases came in insufficient evidence? Is it? 30 of
The
04
cases, yes,
and 35 of 04.
Yes,
Both
Lordship.
are
FR. resulted
FR.
in
Then
FR.
what happened? Then what happened?
Then lordship, he was dismissed from
Why?
service.
Another PS case, 2012. Accordingly, another DP was also. You are
Lordship,
appearing,
paragraph 12, lordship may.
you are appearing for whom?
Lordship, paragraph 12, lordship may come to paragraph 12 of our affidavit, lordship.
Huh?
It is a fact that the petitioner was placed under suspension for his indisciplined conduct on 9/7/2012
Huh?
after his arrest in connection with Sibsagar PS case number 413 of,
Now tell us one thing. He was placed under suspension.
yes, lordship, and DP was.
Please take a note, madam. The questions that are arising in this court, we are going to ask you. You will instruct Mr. S. A. Ahmed if necessary, but you have to answer. Okay, take a note. You suspended him.
Yes,
Did you
lordship.
give him any subsistence allowance in the interregnum? His
That, lordship,
specific
it is not-
allegation is on page 13. No subsistence allowance was paid.
Lordship.
Huh?
For that, lordship, we will have to
See,
have the records of the case, lordship.
person suspended faces a DP without subsistence allowance,
Yes,
entire DP goes.
yes, lordship.
You know the law?
Yes, lordship.
Charge sheet, what was the charge against him? If it is based on the criminal proceedings entirely,
Lordship.
you're proceeding parallelly on the same charges and the same set
Lordship.
of evidence.
Evidences.
DP has to go,
Yes,
or at least kept in abeyance till the
in
time.
the disposal of the.
Ah.
cases.
So we don't know what is the answer in the criminal proceedings. There is nothing on record. It's a police case.
Police case.
We can find out.
Yes, lordship.
Thirdly, the show cause notice. We just delivered a judgment now.
Lordship.
The inquiry report, second show cause notice, what it cannot contain.
Yes.
What it
lordship.
can contain is another
Yes,
thing. What
lordship.
it cannot contain. Now come to the first charge sheet.
Lordship.
You should show cause why a penalty should not be imposed upon you on the following charges. Therefore, you are already made up your mind to give the penalty.
Yes.
What is the
predetermined,
DP about?
Lordship.
The mind is already there.
Yes, lordship.
So these 4-5 things are only what we are trying to look into to see whether the DP is correct or not. We will not look into the allegations. He might have murdered someone. He might have stolen 2 rupees
Lordship.
from the fund. We are not concerned. He might have assisted someone in the. We are not concerned. We are concerned you have taken a disciplinary proceeding against him, whether these factors are,
Complied with or not.
and if there is nothing on record, presumption will have to go towards the petitioner.
Lordship.
We cannot presume against him. You can, disciplinary authority can. 226 cannot.
Lordship. Lordship, once we have the record.
If the petition contains basic statements which are not answered properly, then the benefit goes to the petitioner.
Lordship.
Is it not?
Yes, lordship.
Yes, he says something. Trial case, he was acquitted from the charges. Please come to page 31. The affidavit in reply, he is acquitted in the trial case. So therefore, we need to know what is the charge in the trial and what is the charge before the DP.
DP.
That is all we need to know. From what the order says, the DP order says, what? That it was his duty to have informed
Informed his seniors about the
incident.
incident, but he chose not to.
Now, if there is no incident, is it not? It can be beyond reasonable doubt not proved, or that the incident itself is not proved. Then what happens? And how does he prove his innocence? I should have informed what witness he will bring. He did not inform, it's a fact. When was he appointed?
Page 22 is the charge sheet that they have annexed to
Of?
their petition.
In the case,
Yes,
a
Lordship.
police case.
Page 20.
Page 22.
22.
Page 20 is the handwritten part. Page
Handwritten
22 is
part.
the at least till 2016 they had the records.
Lordship,
If you find page 23,
Lordship.
the appellate authority has gone through the records.
Yes, they have gone through the records and appeal have been, appeal has
Okay,
been.
he has gone through the records. Why are the records not being provided to you?
Lordship, I will take
Who
up
will bring it? Who is the officer concerned of the respondent authorities who will bring the records?
the superintendent of police,
He will
Sipsagar.
not come. Why will he come? He keeps changing in the office. He has taken down heard Miss
Okay, that.
A. Das, learned counsel appearing for the petitioner on behalf of Mr.
SAM.
Also heard Miss
U Sharma.
Sharma, learned counsel appearing for the
For all the
respondent,
for all the respondents.
all the respondents, full stop. It has been submitted that the records called for by the learned counsel has not been supplied to her as yet, full stop. The order dated 22/7/2025 records that for determining the controversy, comma, the relevant records from the department be called for. Full stop. List this matter again on
Day after tomorrow.
records will
The records will not come, Lordship. 2 weeks, Lordship.
from Jorhat. From Jorhat,
Lordship. Jorhat. DIGP Lord Jorhat.
12th.
Lordship.
It's almost 10 days, 12th.
Lordship.
12th of February 2026, on which date the superintendent of police, Jorhat, oh, who?
Sipsagar. Dismissal order is passed by the SP Sipsagar, Lordship.
And who passed the appellate authority? Which appellate authority?
DIGP
Ah.
Jorhat.
On which date the DIGP Eastern Range Assam, Jorhat shall ensure that the records relevant to this case relevant to the disciplinary proceeding of the petitioner shall be made available to this court, full stop, in the absence of providing such records, comma, the aforesaid authority shall ensure a responsible officer dealing with the files with regard to disciplinary proceeding or appeals of disciplinary proceeding in his office shall remain personally present in the court. List again on 16, on 13/2. Or did we say 12/2? 12/2. Even below? 12/2, 2026. Please go through the file.
Obliged.
Right.
Yes, sir.
My lord, the petitioner for your lordship in the constable, my lord.
Ah.
Inherited constable under CRPF, my lord.
Okay.
He was appointed in 2011, my lord.
Hmm.
And 2016, one incident happened, my lord. That on that day, my lord, while he was cleaning the bathroom, my lord, 5 bullets were fired, my lord. 1 bullet hit him on the left chest, my lord. He was injured. At the hospital, he recovered, my lord. Thereafter, disciplinary proceeding was initiated against him.
It was his gun.
That is not our case, my lord.
No, was it his gun?
No, not his gun, my lord.
It's not his
No,
gun.
no, not his gun.
Who fired at him?
We could not see, my lord, because he was cleaning, my lord. Bullets came and one hit his chest, my lord. And but
He
the
was?
disciplinary proceeding was drawn on the assumption that, my lord, I took a chance to commit suicide, my lord.
So it is your gun.
No, not my gun.
The gun was not yours.
Not my gun. There are
Okay.
2 charges, my lord.
Hmm.
One, that I attempted suicide, and second charge is, my lord, I used somebody other's
Oh,
weapon, my lord. These are the 2 charges, my lord.
okay.
That's from a charge sheet is at page, my lord, 24, my lord. The other side is absent, my
No issues. What are your grounds for challenge?
mainly, my lord, in the disciplinary proceeding, I admitted at some point, my lord, that is my case is that out of fear only I admitted, my lord.
Was the proceeding continued?
He is not
Full
concluded, my lord.
departmental proceeding?
Concluded, my lord, I have been removed from service, my lord.
No.
My lord.
Is the penalty imposed only on the ground of your confession? Or they had a full departmental
Full
inquiry
departmental proceeding, full.
and then they say that
Yes, my lord.
with or without the confession, it stands proved.
Yes, my lord. They took my confession also, my lord, admission also, my lord, and other evidence also, my lord.
Where is that impugned order?
Yes, my lord. Page 141, my lord.
Page 1,
141, my lord. Annexure 11.
enquiry report.
No, this is my
Enquiry report.
inquiry report is at my lord. 101, my lord. 101, my lord. It starts from 102, my lord. 101 is forwarding, my lord.
Where is the presenting officer's brief? Can you reply there too? Presenting officer, yes. How many witnesses?
11 witnesses, my lord.
11.
Eight persons, my lord. 8 witnesses.
Where do they start?
Yes, my lord.
You did not cross-examine.
Cross-examined, my lord.
No cross-examine.
He was given the opportunity, my lord. He did not. It starts from 74, my lord. Statement 45 onwards, my lord. 45 onwards, my lord, up to 86.
Page 45 onwards.
Yes, my lord, 45 onwards.
There is no assistant SG appearing. This is item number?
19, white alloy, my lord. White alloy appears, my lord.
No
Double
question on spot. Any affidavit file?
Yes, my lord. It is fine, my lord. was with duty with my this Kakaram, my lord, that annexure 5 my lord statement. I was what with him, my lord. Company commander.
Who is this Kakaram?
He's the company commander. I was attached to him, my lord. In fact, I was a runner, my lord. But I was engaged with him, my lord, attached to him. My duty is to send post letters from one place to other, my lord. But I was attached to him, my lord. And he used to misbehave me a lot, my lord.
Who?
That Kakaram, my lord.
So therefore,
But this is not the reason. my
I would
lord.
have understood if the muzzle was pointed towards something else. It was pointed towards yourself. Huh? Oh yes.
Immediately after the incident, he came out, my lord, from his office, and I requested him, please save me, my lord.
Have you seen page 50? Yes, kindly help us. I will be drawing this. Page 50,
Yes, my lord.
question number 10.
Yes, my lord. Listen.
In law, what type of a question is that?
How did you came to learn that personal number Iman Jyotibhai was shot at himself?
Now, what kind of a question is that?
It was
Is it a leading question? No, it is not a leading question. Is it?
not a leading question.
It is not.
How did you come to learn personal number Iman Jyotibhai was shot at himself? It was asked to my lord, that company commander, my lord.
Who? The inquiry officer is asking the question.
Yes, my lord.
Does he know the answer? From the evidence, he knows the answer.
From the evidence,
Okay,
my lord, you will
then
count.
page number 51, question number 11.
Did personal number Iman tell you that he had shot himself? Yes, he says yes, my lord. Because I told that out of fear, my lord, he thinks, my lord. When he came out and tell me, I have thought of myself. Please save me, please. No, because this was not said, my lord. I have sorted it myself. It was not said, my lord. Only say, it was said, my lord, please save me. It was said.
Ramlakhan Sharma. Kindly come prepared with Ramlakhan Sharma. Kindly go through all the evidence that's available. Point out any defect that you have in
The evidence, my lord.
the inquiry proceedings.
Detail person, my lord.
When would the inquiry proceedings fail? Good enough.
Fine.
Is there any statement that you were asked to give your defense?
Here I am, my lord.
Where is your statement recorded?
Yes, my statement. Yes, my lord. Page 78, 77, 78, my lord. 74 also, my lord. Two statements are here, my lord. 74 to 77 and 77 to 86.
70?
74 onwards, my lord.
When can we have it, sir?
Next week, my lord.
It is your option of a date. Give us a date of your choice. Have it a hearing day.
Yes, my lord, that is one. Thursday, my lord, 26. 12, my lord.
Yes.
Well.
This one appears for the petitioner. None appears for the respondent, although the matter is of the year 2017. Then affidavit in opposition has already been filed. Stop. The matter had been listed in the hearing column. Stop. List again on the 12th of February 2026. 526. On which day? The matter would be taken up and disposal. I don't be closing the inquiry. This, I may have shot myself, I may not have. This court cannot interfere. If you can find out a good ground. Proceed here.
My lord. Obliged. Your seventh, my lord, kindly check page 77.
Page 77.
77.
What is it? Dismissal.
My lord, after dismissal, my lord, this honorable court interfered and directed the respondent bank to review the matter. And subsequently, my lord, that order was passed.
Where is the order of this court?
Court, my lord, kindly see, my lord, page 67, comparative portion, page 75. Paragraph 31. That being the position, the court is of the opinion contrary and that impugn order dated 18/11.
Just a minute.
My lord.
What is your prayer now?
Your my lord, back wages.
Huh?
Back wages. My lord, kindly see page 77, my lord.
Was it not to be taken, was that not a ground to be taken in the earlier writ petition?
But
When you challenge the penalty order?
Challenge the my lord, dismissal order, my lord. That,
So the dismissal order, if set
it
aside,
is
you
a-
are reinstated in service.
Oh, my lord,
If you are reinstated in service, it has to be with consequential benefits,
my lord.
including back wages, that would
But
have been rejected
that-
or accepted.
In the meantime, I am superannuated, my lord.
Could be.
That's why, my lord, the interior order was passed, my lord.
Huh?
Optionally, my lord, kindly see page 70,
Notionally, you have got it.
my lord. And only, my lord, amount of gratuity and leave salary amount has been paid.
There is no pension.
No pension, my lord, there.
In the bank, there is no pension, sir?
No,
This bank does not have a pension facility.
they have a pension facility.
Then why you have not given it to him?
Maybe he's getting most probably he's getting a pension a lot.
However, for the purpose of giving full superannuation benefit, what do you mean?
That whole, the pension benefits and everything.
So where is it? What is superannuation benefit? The horse pension?
Your lord.
Like,
Oof. Your prayer is for pension,
He's paying your back wages.
back wages.
only back wages.
Only back
And
wages.
recalculation of the, my lord, the gratuity and leave encashment, my lord.
That means the bank does not have a facility for pension.
Pension.
Is it pensionable service?
They do not have regular pension, my lord. They only have accumulated pension. That has
What
been
is,
released.
what is accumulated pension?
Oh, it is like,
No. I am asking here in page 77. Where is that accumulated pension part? Is the amount of gratuity and amount of leave salary you are trying to call as accumulated pension? Cannot be.
no, in our affidavit,
Leave salary is right.
we have mentioned that as pensionary benefit, whatever was due, that has been paid. Back wages, my lord,
Yes, your order was wrong. Your order was wrong, not on the basis of a, what do you say? principles of violation of principles of natural justice. Your order was wrong because you had framed a mine on the inquiry report itself without taking any notice of the plea raised by him. So does it stop at violation of the principles of natural justice? No. This was a case where there is a malice in law. You frame your mind before you punish him, before you hear him on the inquiry report, before you don't even discuss what was there against him in the inquiry report. Is it not? That is what the earlier judgment held. We are not saying that. Let us read the earlier judgment.
Yes, 67.
No. Page 75, para 30. Please read. We are not disposing today. You'll have your time to go through any judgment you can bring to us. Page 75,
Para 31.
30. 30.
That being the
No, no,
position.
30. What was the
30.
position? Para 30. at
From
page
a
75.
careful
Ah.
perusal of the impugned order as extracted above, it is evident that the disciplinary authority simply accepted the findings of the inquiry officer
Hmm.
and thereafter decided to impose the penalty of dismissal from service on the petitioner. It goes without saying that the inquiry report is only an opinion. Ultimate decision-taking authority is the disciplinary authority,
Hmm.
who has to take the final decision on the disciplinary proceeding drawn up against the delinquent employee.
Hmm.
The inquiry report certainly is a relevant material to be considered by the disciplinary authority while considering guilt or otherwise of the delinquent. But the disciplinary authority has to give its own finding on each of the charges framed against the delinquent, which must be supported by cogent reasons. All these are not discernible from the impugned order. Moreover, when the staff rules provide for multiple penalties, it becomes necessary for the disciplinary authority to examine as to which one of the several penalties would be appropriate, keeping in mind the gravity of the misconduct. Some application of mind to the imposition of penalty must be discernible from the impugned order. Here also, such application of mind is not discernible.
So now let us stop here for a minute. This is not because he did not have a chance. He missed the bus. It is not that. Here is a case where the disciplinary authority is predetermined or has not applied his mind. Either of the two. In both the cases, the order becomes what? Illegal, not unlawful. It becomes an illegal order. Now, having been kept out of his job to an illegal order, just because he has not rendered service to you during that period because of an illegal order, can you withhold back the back wages for that period?
There, my lord, there are three contentions. One, my lord, there have been certain recent apex court judgments
Hmm.
which says that the disciplinary authority need not again frame its independent observation and can simply rely on the inquiry report. But this proceeding is, my lord, already over, and by that time, my lord, the petitioner already retired. So, my lord, the authority at that time thought that instead of imposing anything, he will be given the pensionary benefits, but that period will not be counted as service.
What we are trying to simply find out is denial of back wages on reinstatement, even when the matter is remanded back to you.
Yes.
There are some principles which are required to be followed, have been consistently followed. One of them being,
Gainful employment.
and whether the order was illegal, whether he was forced to be out of service or whether he was required to have reported but he did not, or he delayed the proceedings. He did something which, then again you will see the gravity of the misconduct and the penalty was not taken into account. That was what was required to be done by the earlier order of the court. Even that has not been done here. We do not, if I read the second order, I do not know what is the gravity of the offense. I do not know why that reinstatement question was out. Let us say, the moment you say that your reinstatement is out of question, then what does it mean? That means we do not propose to throw you out of service. So we do not know the extent of the penalty sought to be imposed. Therefore, we assume that no penalty was proposed. A reinstatement would have been the result had he that period of service left. Is it not? This is
That
what the,
liberty was given, my lord.
so what did you say in the order? In terms of the aforesaid order, the bank has decided to review the earlier order dismissing you from the service of the bank. So we are taking back the dismissal. Now what are we required to do? If found guilty, propose a penalty, not impose it before because you have already retired, but deny you other benefits which would have arisen. That would have been a penalty. Now you say we are not reinstating you because you have retired. In other words, once the dismissal is taken back, we would have reinstated you, allowed you to work. Therefore, you do not stick to the penalty of dismissal. Is it not? Now, when you did not allow him to work, would you take away what would have accrued to him also? In turn, making it into a penalty. When you have not decided on the gravity of the misconduct and the quantum of penalty required to be imposed. If that be so, since he has not worked, whatever TA, DA, all those things which would have been there if he had actually served would go. But then his leave salary would come in, which he would have earned when he had not worked, but was put on a forced leave. That much entitlement he would have. You have already given whatever you had to give him, the amount of gratuity and the leave salary on the basis of, on the notional basis. So that does not come into play now.
Yes.
But he was on forced leave effectively. Would that forced leave salary not come into play? When you did not impose any penalty on him, had this order said for once that we hold you guilty, since you have already gone, we are not giving you a retrospective, we cannot give you a retrospective dismissal. So what has happened has happened. We are being benevolent. Take this much, please don't come. Another, nothing reflecting. You say we are taking back the dismissal. We cannot reinstate you because you have reached the age of superannuation. But no work, no pay because you did not work. He did not work because you did not allow him to. Get the point?
Yes.
That is the difference. That is the difference between the judgment that you have referred to when saying the inquiry report can be taken into account without taking anything else into account. Yet, if he can make a point on the inquiry report, that has to be considered. He did not take away, he did not discuss all the judgment or all the facts, but where he differs from the inquiry officer, that has to be discussed. Not turn your shut house. Otherwise, his representation becomes zero. No value. Something has to be discussed. Number one. Number two, you took back the dismissal order and you have not reinstated him because he has reached a particular age, not as a penalty. In that circumstances, would he be entitled to the leave salary? If not the entire back wages. We are not inclined on the entire back wages part. But what he would have earned had he been kept on forced leave or on suspension. Something comes to him. The law also says there are judgments of this court which says that from the date of the termination to the date when the fresh decision is taken, he is under deemed suspension, entitled to
Leave salary.
subsistence allowance. Nothing else. 50% 3 months, rest of the time 7 months. Why? Rest of the time 70%. Why? So that you don't delay the proceedings, keeping him hungry. I think Justice Naya solved it. That he will be entitled to the salary. If you go in university, it is in appeal. That's it. I don't know what has happened in the appeal, but that was the order passed by the single bench, and there a good discussion has been made as to why in between this period you would be entitled to suspension, at least the subsistence allowance or the leave salary. Leave salary was not taken into account. Here, in this particular case, it is equivalent to a forced leave. So minus all the allowances, the basic comes to him. Or the subsistence allowance, whichever you choose. When?
Any date next week?
Choose your date. We are here.
24th.
24th. We are not recording all this. heard the consensus for the parties at length. List again on 24th, allowing the learned counsel for the respondents, Mr. Ibor Thakur, to have his instructions in the matter.
Parthat Malo.
Eh?
Parthat Malo.
Why? He has said at the matter at length. Come up with something to show us that you can deny it to him. Once you have decided not to impose a penalty on him, that has to be the tag. If there is a judgment,
I'll look.
that kind of a thing. Yes, next. Good. Yes, sir.
80.
Hmm.
So kindly take up WBC 3381 now.
3381. Thank you. Mr. Bhattacharya, would you be appearing in the matter?
Matter relates to
We can hear it, because otherwise if we hear it, we are not keeping anything more part heard. We will just try to finish the matter if it is.
Finance is a party respondent. Finance have, in both the matters, we have filed our affidavit identical. Administrative department is the home department. Now matter relates to pay parity. Now petitioners are working in APRO, Assam Police Radio Organization, in the rank of constables, havildar, so on and so forth. Now they are seeking pay parity with regard to their counterparts who are regular police officers in the police department.
Having the same designation.
same day.
No, designations are different.
No, what I'm saying, here the designation is a constable, there also the designation
Yes,
is constable.
Yes, yes.
Here it would be some ASI, that would be some ASI, that would be SI, Havaldar.
Yes, sir.
So designations are, the
Very
ranks are equal, but the pays are different.
Pays are defined and they are with regard to increasing the grade pay. Because increment in the grade pay.
Increments.
Increments in the grade pay. Now, so far as my lord, the pay commissions are concerned, grade pays were increased. Now, the grade pays of the other officers with whom they are trying to draw a comparison have been increased. They have made similar demands. Now, their demands were turned down on the primary ground and basic, that is the solitary ground, it appears from the pleadings, my lord, that the pay commission, neither the pay commission nor the anomaly committee, which is constituted for rectifying all those minor parameters after the pay commission, neither the pay commission nor the anomaly committee had made any recommendation with regard to increasing their grade.
But was it taken into consideration by either the commission or the anomaly committee?
No.
If not, it has to be.
So therefore,
Since they are raising a grievance, we are not experts.
yes, so therefore, they
So
were,
at least that relief.
yes, so therefore,
Now,
the-
if they can
the
show that.
interim, the impugned action on the impugned minor order on minor which have been issued by the administrative department has in fact advised them to raise their grievances before the next pay commission. Because that is an expert body. So this is precisely the issue involved. The pleadings are otherwise complete. Now, they will have to satisfy this honorable court that they are doing exactly identical duties. And that can only be spelled out, my lord, from the affidavit filed by the police authorities. I find affidavits filed by the superintendent of police.
They have given a, so you have given a chart. You have given a chart at page 21. There apparently,
It's 22 number.
page 21,
WBC
WPC, the one that you had suggested,
3381.
the one that you have suggested, we have. Page 22, do you have it?
Yes.
P3?
20
8-1 of 2021.
Yes, madam.
Do you have page 22?
Yes, madam.
There is a chart.
Yes.
In this chart, all Assam Police Association proposal received from is the first column.
Yes.
Second column is demand oblique proposal.
Yes.
Now this demand which has been highlighted, bold, was it placed before the commission?
Yes, ma'am.
And what did the commission say?
The commission, what the commission has done, madam.
You say here
Given the ROP,
recommendations,
specific
views of the
allocation.
anomaly committee, recommendation of views of the anomaly committee has made suitable recommendation in this regard. What is that recommendation?
But ROP I have given.
Please,
I have given.
which should I say, which one should I take up?
ROP 27.
Page?
Malad, in first tag, my lord, possibly can you see Home Department, page number 21.
Just a minute.
First tag, my lord. No, my lord, not inside, my lord. Just fourth page.
That is the first tag.
Fourth page.
Fourth page.
Not page. In the index, my lord.
Ah.
Page number 21.
Hmm.
Home Department.
Hmm.
Director General of Police.
Hmm.
Director General of Civil Defense. In Home Department, madam, these are the some heads, madam. Possibly kindly can stand to. Page 510.
Hmm.
510.
Yes.
We are under the Director of General of Police.
Hmm.
In respect of Home Department, there are some recommendations.
Yes.
In respect of Assam Police reorganization, is within the Home Department, madam. Possibility. Home Department, serial number 1, Director General of Police. The Director General of Police, these are the subheads, madam. The Border River Police Organization, some police organization, Bureau of Investigation. We are at 550. Number. Next, we'll see. The report of the 750 and for the
Is there any difference in the pay scale given to a Havaldar?
no, my
To Havaldar. Head constable in addition. Then we have a sub-inspector. Sub-inspector, 8700, sub-inspector. 8700. Constable 5600, constable. So with the others, you do not have any difference, then?
no difference. Then must we kindly see the report of the 7th pay and productivity committee, my lord. Other bounded volume, my lord. The other bounded volume I will give, my lord.
Other?
Bounded volume, my lord. Must we kindly turn to page 154. Serial number 1.17, Home Department. And serial number 2, Commission recommends that PP for constable and other ranks up to the level of ASI should be as follows. Has been given, my lord. But, my lord, same PP shall be allowed for the equivalent ranks of home guards also. Because in updates, my lord, home guards were differently placed in the ROP. But the APRO was along with the parent department. So for APRO, there was no separate recommendation. Because of the home guards were placed in the different subhead, there is a different recommendation. But this recommendation, the first recommendation, covers the APRO also. Doesn't say that they are excluded. This has been misunderstood by the authority. They say that in this recommendation, the APR was not included.
Okay.
That is their case.
So what is your Iman, now here the constable was given a grade pay of 2200.
Yes, madam.
In page 518, if it refers to you. No, sorry, not 518. Page. Which page? Page.
Page number 515.
515.
5.
Page 515, the constable has got 2200. And we don't have Lance Nayak. Then you have Havaldar. Havaldar is having 2200. Okay. And ASI, where is ASI? Don't have an ASI. Assistant Sub Inspector, yes. Assistant Sub Inspector 2400. So your people are head constable and ASI.
My lord.
Constable has 2200 grade pay.
Yes. But
The
this
constables
has-
are not
this
with
has
you.
been Subsequently, my lord, by the anomaly committee, my lord. Anomaly committee has enhanced this grade pay.
The constables have not been enhanced.
In respect of APRO, they have not enhanced.
Ah.
Only in respect of APRO, but in respect of the other police officers, my lord, the other department, my lord, they have enhanced. And only on the ground that, my lord, this recommendation at page 154 of the pay and productivity committee it does not specifically mention about the APRO. That is their only ground of denial.
That is your case.
This has been, my lord, clarified by the department, the parent department, my lord. They have clarified that we are same. We are on the same footing. We cannot be distinguished from the other police officers, my lord, other police departments. We cannot be given lesser pay. Now they
You are
saying-
appearing for the police department. Is that so? Your affidavit supports them?
Yes,
I filed one affidavit. Paragraph 7, Lordship of.
Mm. Mm.
Hierarchy is shown, Lordship.
We are just asking. The parent department is saying that they are part of, they should have got it. That is the stand of the parent department. Okay.
So Lordship, just that, the thing is, Lordship, the post of constable, police communication, these are filled up by direct recruitment.
Ah,
And the assistant sub inspector of police communication is a promotional post.
ah.
He recruited.
Kindly tell us, this constable in the general department, is it filled up by promotion? No, it is also filled up by direct recruitment. ASIS is filled up by promotion on both the counts. For the
Lordship,
BA
in the APRO department, Lordship,
Ah.
they have to undergo a police basic drill and discipline training for duration of 39 weeks.
Mm.
Thereafter, police wireless communication course level 3. Then for 6 months plus 9 months, now 15 weeks successful completion of which are mandatory, and on completion of the said courses, they are treated as head constable police communication. Then thereafter also, Lordship, for upgradation, police wireless communication course level 2. Then for 6 months, 12 weeks duration, successful completion of which is mandatory for promotion to the post of assistant sub inspector of police communication. Then, Lordship, in the rank of assistant sub inspector of police communication, they are called for upgrading course called police wireless communication course level 1. Upon successful completion of which is again, that is also mandatory, Lordship.
Okay,
for
we'll come to
promotion
you
the respect.
We'll come to you in a short.
No, what I gather, my lord, in sum and substance from their affidavit, what has been spelled out is the nature and duties performed by the petitioners, the constables in.
And how they get promoted and all.
How they-
What
but-
is that avenue of promotion?
Yes, but with all respect, this affidavit falls short of saying that the jobs, nature and duties that are being performed.
We are not on the jobs, nature and duties, etc. What we would like to know is this page 154, do you have a copy of this?
page 150.
No, of these two documents.
Yes, yes, ROP rules I have.
Now in page 154 of the seventh Assam Pay and Productivity Pay Commission. Point 1.17
Yes,
relates to Home Department.
yes, man.
Can you share a copy? If you're not giving him a copy for permanent use, share a copy
Abstract
during
is
the.
annexed in the petition also.
The extract hereof is a part of the. writ
Now-
petition. Yes,
This one relates to Home Department.
this one relates to Home Department.
At the end of it,
Yes.
they say the commission recommends that if the grade pay for constable and other ranks
Yes,
up to the level of ASI should be as follows.
yes,
When we see constable,
yes, ma'am.
now if you have this pay rules also with you,
Yes, yes, that is with me.
at page 516. probably.
516, yes,
Kindly have page 516.
yes, my lord, I am having it.
It says, if you see from third from the bottom,
Yes, my lord,
it is constable.
yes, and, yes, UB constable,
No, that is the last.
last one.
If you see the third from the.
Yes, 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 yes,
Constable.
constable,
Now,
yes.
unarmed branch constable and constable, we are not making much of a difference.
My lord, my
But constable, it has got 2200.
2200.
So 2200 was recommended at that point of time. This 2200 came into being.
Yes,
Right? Now again, we go back to this
recommended.
seventh pay productivity.
Yes, yes,
Lance Nayak and Nayak we do not have.
yes,
These are not an issue. Now you come to head constable.
yes,
2700 was recommended.
2700,
Right.
yes,
Now, if we come to again page 516,
yes,
you would find that Havaldar is second from the top, second or third from the top, Havaldar.
yes,
He gets 2200.
2200,
Right.
yes,
Now, if you come to the previous part,
yes, D,
no, we are coming to some other organization
yes,
under your this thing only,
yes, my lord.
where we have a Havaldar. Where do we have a Havaldar?
So in fact, here, my lord, that page, my lord, 154 of that book, my lord, that pink book, the last paragraph which lordship has was
Now, please come to page 510.
510 of the ROP rules.
ROPD.
Yes, ma'am. Yes, ma'am.
You see Director General of Police, under the Director General of Police,
Yes, ma'am.
you would find Havaldar was 2200.
Yes,
That
2200
2200 goes up.
goes up.
Which is the other 2200 that needs to go up? Where is the other person where there is a Havaldar?
Wilder and my lord, the head constable.
So I say head constable one more, which was 2200 and became 2700.
Head constable was 2400.
Which became 2700. You said later on it became 20, they were giving 2700 and again enhanced later on.
No,
We are not on the later on enhancement. What we are trying to see is Director General of Police.
if lordship is taking up that page 510 again for a moment, lordship has drawn attention to my lord the last entry, that is Havildar. Havildar lordship will find my lord 2200. That was the existing grade pay.
They made it to 2700 by this.
No, they made it, my lord, that was 5600, 5600. On the right hand
Not on
extreme,
that. What was 2200?
my lord,
If you come to again this one,
yes,
for that 2200 will become 2700
yes,
and therefore 5600 will again go up.
go up. Yes,
That is what is the whole system.
absolutely,
2200 will correspond to 2700, therefore
absolutely,
5600 will go up.
go up.
We are not on that. What we are trying to see is this, at page 510,
Yes,
under the Director General of Police,
yes. We
You
find, we find the
these are
post,
directly these are directly some of them.
Yes.
Then you find on the next page, district establishment.
yes,
Then you find at page 512,
512,
district establishment, it does not have any number before it.
yes,
So it is under the Director General of Police.
yes,
Then you have Border and River Police Organization,
absolutely,
directly under the Director General of Police.
absolutely.
Then you have Bureau of Investigation,
Yes, my lord,
directly under the Director General of Police.
yes,
Then you have Assam Police Radio Organization.
Yes.
Why deny them? It is under the Director General of Police.
no, Assam Police Radio Organization was,
Is
yes,
equivalent to BRO. A BI, a BO, BOI.
no,
Bureau of
yes,
Investigation.
for a moment, lordship will kindly come to page 510 again.
Yes, yes.
Yes, I'm troubling my,
Ah,
it is
we are here to be trouble.
I'm obliged, madam.
Yes. 510.
510,
Huh,
Lordship will find that the broad category is home department.
yes.
Lordship will kindly mark this, it is home department. Under the home department,
Mm.
these are the subcategories.
Yes.
Number one is the Director General of Police.
Huh,
In Director General of Police, Lordship has seen, my lord, at
Mm.
page 510,
huh,
the post of Havildar figures,
yes,
post of Havildar.
yes,
And the post of Health Constable is there just prior to Havildar.
yes.
Lordship will just keep this for a moment and then Lordship will come down. Then Lordship will see district establishment border, so and so.
It does not have.
This-
Border and river police does not have.
Does not have, then my lord will kindly come to the next, my lord, Bureau of Investigation.
Ah, it does not have.
Because these are different sub-organizations within the home department.
Very.
Under
Now,
the,
these are sub-organizations not under the home department. These are
Under-
directly sub-organization under the Director General
Director-
of Police.
Director General,
Under the home department,
Under the
it's
home de-
Director General of Police,
yes,
then you have. Where is two?
Two is,
There
my
is
lord,
supposed to
page
be a
517, madam.
Huh?
517.
517,
Right. See, Director General of Civil Defense becomes another thing.
yes,
And then you will have the third part, which will say Director of Home Guards.
Director of Home. And,
You will
at,
find it at page. Just a minute. Just a minute. Where was the Home Guard part? You saw it? Where does the Home Guard?
No, no,
come?
this is Director General of Civil Defense and Commandant General of Home Guard.
Home Guard, you see?
Yes.
So Director General of Police is a separate thing,
yes,
is a subclass,
yes,
and Directorate General of Civil Defense and Commandant General of Home Guards.
yes.
That is the second subclass.
That-
Now, when this was given to the entire subclass of the Director General of Police,
Yes. Landslide, yes, yes, sir, yes,
apprehending that it will not be given to the Home Guards.
yes,
Therefore, at page 154 of this book,
yes,
a clarification is given
Yeah.
that it will be allowed for equivalent ranks in Home Guard,
Yes, sir.
yes.
right?
Fine,
Nothing in Director General of Police, this
Yes.
first subclass was left out.
yes.
But everything else
Yes.
except Home Guards of equivalent
Yes,
rank
yes,
in subclass 2 has been left out.
left out,
Therefore, everything included under Director General of Police,
police,
including everybody in APRO
yes.
with equivalent ranks, has have to have the same grade pay.
That appears to be, my lord, the
Intent.
my lord, quite, my lord, my lord, very natural interpretation of this, my lord, recommendation. But the affidavit says that since there is no
Whose
specific,
affidavit?
my lord, our affidavit and their affidavit also.
Your affidavit and their affidavit would have been important to us to decide the nature of the duties, the way of hierarchy, the how they come in, what is the education, everything would come in. Had they come from the air and said, we are doing the same thing, please grant it to us. There is a
Yes,
anomaly in the,
yes. Now, that,
there is an
yes.
anomaly in fixation of our pay.
Absolutely.
They have left us out, sir.
Yes,
Then I would have asked them.
yes.
Now,
Now, here
air
is a
cases,
where,
we are
yes,
in. We are
Lordship
being
is,
denied.
lordship is,
So we will not go into that part.
yes. So meaning thereby, fellow, that lordship has interpreted this to be as if it is a,
Two subclasses
yes, my lord,
under
Havildar,
home department.
Havildar would mean and include, my lord, that Havildar of the.
All Havildars under the Director General of Police
And-
and only those Havildars who are in the Home Guard section. have
As,
it
as
set
well as APRO.
Huh?
As well as
APR comes under DGP.
So APRO comes, no, now they were denied because they were under the APRO. Let us come to that manner, because
They
they were
come
under,
under the APRO later. They come under the DGP first.
so DGP first, but the authorities, what they have said, my lord, in our affidavit, that there was no specific recommendation with regard to APRO, meaning thereby,
Can you say that there was any specific recommendation
yes,
in so far as the other persons are concerned, River Police?
Yes, sir.
River Police, let us not take Havaldar,
yes,
let us take the SI post.
yes, my lord,
That is available for River Police?
yes, my lord.
Have they been given the benefit of 1.17 within bracket 2 at page 144? 154.
Yes, my-
If riverine police have got it,
my lord,
if district establishments have got it,
my lord. Then why not them?
then why not them?
Yeah, because
Then
they
you cannot
come,
make the difference.
yes, so they come under the same umbrella.
Now tell, now you have to tell us, district establishment did not get it. Border and river police, none of them have got it. Not, I'm not talking about constable or havaldar.
Yes.
Anybody who had a rank equal,
Who had a
they were not given the benefit. If
Yes.
that be so, they don't have a case. But if they have got it,
Yes. Taking this, my
under
lord,
subclass 1,
Yes.
Director General of Police,
making a plain interpretation of that
all other
recommendation.
subclassifications under Director General of Police have got it, 7 except APRO.
APRO.
Then you don't have a case.
Yes.
Nobody else has got it except those working under no head. Under no head, it doesn't have a head.
Lordship is correct, yes.
Headless people have, only headless people has got it,
Yes.
then he does not have a
No,
case.
absolutely,
If
absolutely.
everybody with a head and the headless
Yes,
have got
yes,
it,
yes.
he has
Because,
a head.
no, definitely, because
Definitely.
their rejection
Mm.
is founded on the decision taken by the finance department. We say, well, that since there is no specific recommendation. Rightly, wrongly, we say, my lord, that there is no specific recommendation with regard to APRO.
We had,
Meaning, no, my lord, meaning thereby that we are treating APRO to be a very specific cadre. So
now
therefore,
what we are trying to say is,
Yeah.
the person who signed the affidavit or the person who's trying to understand the law
Right.
was perhaps not the person who had made those recommendations or who had
Yes,
been a part of
yes.
that recommending
absolutely.
thing. So therefore, when Mr. Bhattacharya appears before this court, the expectation is that the law would be discussed, not what has been given by a defendant in his
Absolutely.
affidavit, whether it is right or wrong.
Absolutely, absolutely.
We
absolutely.
know we cannot extract a concession from you. but
Lordship is correct. So
we cannot
therefore,
extract a concession from you.
Therefore, my lord, under that circumstances, in order to be doubly clear, my lord, let us
I'm
get
giving you
the,
the time.
yes,
I'm
let us,
giving you the time.
let us get the instruction and lordship may kindly make that observation because that will cleanse the issue. That will cleanse the issue.
Everybody under the DGP gets it, even except the APRO.
APRO.
Since DGP and the other one, the Home Guard part,
Yes,
are two different subclasses
Yes.
within the class of home department.
yes,
Therefore, there is a clarification that the Home Guard's equivalent rank would also get it.
yes.
No clarification was required for the other subclasses under DGP. Not given.
So home guard.
Actually, the commission perhaps made a mistake. They thought people would understand. But they are so complex in their recommendations, people fail to understand.
Because let apart home guards, we find a post of constable and havildar in all other subclasses. APRO also have constable subclass. But what my intention is, my lord, we find the post of constable and havildar in APRO. We find identical post in other my lord, sub-organizations. Let us keep apart the home guards for the time. being. They are altogether on defined footing. Now, the recommendation that is at page 154 down the last paragraph which lordship, because this is causing a trouble. Now, whether the recommendation made herein would mean and include all these home guards, all these constables and havildars, that is the answer. Because we say, because we say we do not find out.
Where is that sentence? Show us.
Because we say that we do not find in specific those words, my lord, that APRO. So therefore, we are denying.
This clarification at page 105.
Huh?
105, my lord,
105.
of the recommendation level.
You said their affidavit says. Show us the affidavit, right? Huh?
This is the, my lord, the
You said their
clarification-
affidavit
This is the
says, we were
clarification, my
taking
lord.
your word for it.
This is the clarification given by the additional director general of police. to the-
Kindly
to the-
show us in their affidavit. You said affidavit, sir. Because there are times when we dictate an order or we form a prenomination, we do it because the council has said it.
No, no, my lord.
If you had said their letters said it, we would have read it. You said the affidavit said it. On oath also. Good. That is what we were trying to.
Lordship may be pleased to see the affidavit, my lord, filed by the respondent number 8.
Page.
Running page, my lord, I'm sorry, my lord, I'm not.
Some indication.
Yeah, my lord, the Aswini Nursery, my lord, the
Respondent number 8, yes, we found it.
Yes, that is on 24th of
No,
September.
we got it, we got it.
Yes, so that is the affidavit where, my lord, the nature of duties and responsibilities have been spelled out. This is by the parent department.
Paragraph 6.
Yes,
Uh,
paragraph 6.
It is somewhat to that effect, that there has been an anomaly in fixing their pay. So ultimately,
That is.
the correct interpretation of what is being.
Has also been said.
Hmm.
Proposal has also been said.
Hmm?
Proposal has also been said. That is why, my lord. And while turning down the proposal, my lord, the finance department says
Ah,
that there is no specific recommendation in respect of the APR. That is only reason, my lord, for which, my lord, they were
heard
denied.
Mr. I.X. Sekia, Learned Counsel appearing for the petitioner. Also heard Ms. U. Sharma, Learned Counsel appearing for the respondent number. So, and Mr. R. Borpujari, Learned Counsel appearing for the respondent number
2, my lord,
2.
in both the
The-
matters.
The Home Department and the Finance Department have filed their respective affidavits, which are on record, and the petitioners have filed their reply. Have you? Both?
Yes.
Both the affidavits. The, during the course of arguments being placed to this court, attention of the court was drawn to this one, page to the Assam Service Revision of Pay Rules 2017, including revised pay structure schedules within the department-wise published in the extraordinary issue of the Assam Gazette number 74 on 17th of March 2017 by Mr. Ayat Saikia, who impressed that under the Home Department, two broad categories could be mentioned, with one of which is the Director General of Police and the other being the Director General of Civil Defense and Commandant General of Home Guards, full stop. Mr. Ayat Saikia has submitted that the different establishments under the Director General of Police have been given the benefit of the pay revision as proposed by the 7th Assam Pay and Productivity Pay Commission. This is what report. As reflected in clause 1.17 within bracket numerical 2. What, okay, huh? Comma, where the commission recommended that the grade pay for constable and other ranks up to the level of ASI would be as follows. Kindly take on page 154. A surplus to the application.
That is a part, that is also part of the rate petition matter, Annexure G, page 81.
Which is also available at Annexure G, page 81 of the writ petition.
Right.
The Learned Counsel for the petitioner has submitted that corresponding ranks as held by the writ petitioners hearing in the other sub-organization, namely the Direct Establishment, Border and River Police Organization, Bureau of Investigation, etc., where corresponding ranks exist, have been given the benefit because they have been considered to be under the category or under this classification, under the what? Under the Director General of Police. Full stop. However, since only the incumbents serving in the APRO, which also comes under the Director General of Police, have been denied the benefits for no reason which can be upheld in law. Full stop. the learned counsel appearing for the finance department has submitted that the report of the seventh Assam Pay and Productivity Pay Commission had given the benefits only to the persons working under the Director General of Police and to corresponding ranks of the Home Guards. Full stop. He says that since there is no, he submits that since there is no reference to any of the other sub-organizations under the Director General of Police, therefore, the incumbents serving in the Assam Police Radio Organization have been denied the benefits.
Yes. Yes.
On the next date fixed, Mr. Arbo Pujari, learned counsel looking for the finance department, shall inform this court as to whether the incumbents holding a corresponding rank in the other sub-organizations, whether or not equivalent to the petitioners, but when they exist concurrently in two sub-organizations, have been given the benefit of the Seventh Pay Commission 1.17 within bracket 2.
Yes.
Yes.
Yes. Yes.
Just for further hearing. No, this court is of the opinion that if the benefits have been given to the other sub-organizations under the Director General of Police, the reasons given in the order rejecting a similar pay scale to the petitioners may require a stronger defense by the respondents. In case none of them have been given, the petitioners may be required to put up a stronger case. Well, last of the I will leave. Huh?
Proceeding if they just my
Then we have to frame a subclass there outside where our name is written. Bench for further hearing. Did you say after some hearing? For question, during the question, arguments for during the question. It's again for hearing on
next to.
your convenience. It is your document. you have
Yes,
to bring.
yes, my lord. Can it be, my lord, on 17th of February, my lord?
17th of February.
My lord, it is Tuesday, my lord.
As part of matter, I have given the written argument also. Have given.
You need to record all that.
I've got another copy.
If it is there, it is there. If it is not there, give us a synopsis.
I have given everything.
Written arguments tend to be longer than verbal, oral arguments, verbal arguments.
Synopsis of the argument.
Otherwise, if
17, we don't want to keep it on 17, it is too full.
my lord,
It
then
will be on 19,
my lord, can it be on 24th, my lord? subject to-
24th, 24th পাইলে? তাতো বহুত হইব। 24th,
Yes, 24th.
As part of matter. As part of matter.
I said for further hearing.
On that day I will be fasting, my lord. On that day I will be fasting, still my lord, I will. do it.
On 24th,
Yes, sir.
we'll give you a good reason to have a hearty meal in the evening if Mr. Bolpuja is not able to produce document.
Oblige, my lord.
I'm so blessed.
I think 21. বলছি না এগুলো। Keep দেখলে এটা নিয়ে আসবে। এটা নকল জানি কি? এইমাত্র কোনটি গেল? এটা আপন going back. First of all, yes, sir.
For a short accommodation, Mr. S. Bodhakur had to urgently leave this court.
Huh.
I'm seeking for an adjournment today. I'm from the other side also.
There was no objection by you on the last occasion. Some accommodation.
The only
was-
objection that I have today, he informed me just now,
On,
That is something.
not in
we-
the morning.
That is something we face each morning
Yes.
he was there till
and
the
on a
break.
number of matters. What was this, what is the matter about?
Challenging a dismissal order. Industrial Tribunal had upheld that order of dismissal. They have challenged it now.
Concurrent finding is what they say in civil law. The learned counsel for the petitioner has requested for an adjournment today. The same being not objected to by the learned counsel appearing for the
2 to 8.
document
IOC.
number 223, comma. List this matter again on 11th February,
March,
hearing dates.
he is suggesting March,
March,
March.
March 11th. March 11th is a motion day. Why do you want to take a motion day? 10th of March,
10th, I have some difficulty. Let it be on 12th. then.
12th?
12.
on 12th of March, as consented to by both the parties, matter shall be taken up for disposal on the next day.
Obliged.
My lord, today, my lord, for accommodation, my lord, 1 day accommodation, may I be, my lord, is any day, my lord, 10th of the February or, my lord. I'm actually not prepared today, my lord. This is only a small, my lord, the relative promotion, my lord.
I was prepared, otherwise your lordship, but my learned friend, he has.
Huh?
I was otherwise prepared to argue my matter, your lordship.
I
but
want
my
matter,
learned friend, just.
even as to my life prepared, my lord, this is.
Please preferably for more than one matter
No,
in
no.
a day, please.
On 10,
On the request of Mr. S.K. Medhi, learned counsel appearing for the
No, all-
Union of
all- all
India and others, the respondents, which is not objected to by the learned counsel appearing for the petitioner, list this matter again on 12th of March.
Lordship, I have some difficulty on 12.
And then 19 and 9.
Any promotions which have been given or which may be given under the include notification remain subject to outcome to writ petition.
Lordship.
You are not claiming promotion under that notification. You are challenging that notification. Is it not?
Lordship.
So any promotions given, you will have your dues.
Yes.
What in this month and what in that month. Our attempt is to dispose it of, if you
Yes.
take it up. I will fix it on 12th, it will not reach.
My lord, my
It
12,
will not be conducive. So we are fixing it on 12th of March, where we have fixed only
Lord-
two
Lordship.
hearings till now.
Lordship.
12 of March.
Ah,
Lord-
Thursday.
I was thinking, Lordship, thinking on February 12th, I had some matters, so.
Possible.
But if can it be end of this month, your lordship, can it be, if it's
24, 26 full.
24 or 26?
19, there is a request not to fix any more matters. 17, there is a request not to fix any more matters.
20, my lord, 20, my lord, I have asked, my lord.
20 is a Friday.
The hearing, let it be on a hearing day, your lordship,
26 February. 26th of February is the best.
26, your lordship.
26.
Definitely.
26. My lord,
26 মানে এটা 2026 নহয় যে 26 20 জুন নহয়।
my lord, 26, my lord, this
26.
26, my lord, all, my lord, rate appeal is again fixed on 26, division bench, my
We'll
lord.
attempt two cases in a day, sir.
My lord,
Attempt two cases in a day, let us see.
And it is, right,
Whether the promotional policy is something that we can interfere with or not.
my lord, I know.
One simple question.
Yes, my lord.
the issue is that.
If yes,
So, my lord,
we proceed one step forward.
20 also, on 20 February, not the small, it will take up and on.
But then better we can have it on 26, small matter.
Yes. Because main issue, your lordship, is regarding whether
I have some cases.
under the AICT Act regulation.
Third
But
person,
20 will take an attempt.
20.
20 February,
20.
take an attempt.
my lord, it will not take
Deeply obliged.
maximum 30 minutes, my lord. 11.
That is the only thing we run short on, time.
Lordship already go, I have gone from.
Yes, sir. 25, 25. No work, no pay.
No, what, no, what? The picture
Is
is,
that no work, no work, no pay?
yes, Mani. So he has been reinstated, but, on condition that he has no work, no pay. During that, intervening period. As per direction of Honor High Court. So case is that, my lord. He is a constable actually in Simawal. He applied for early, applied for 30 days early on 10/1/19 to 9/2/2019 for treatment of the ailing mother. He went there, the native place. He was there, but unfortunately due to the condition deteriorated, he could not come back.
So on 10 to 2019, he's supposed to join. Why could not joining?
On his reinstatement, when was he supposed to join?
On the
Sorry, sorry. The petitioner had gone on leave. He did not join back. They kept calling for him.
Yes,
He did not go to join.
he did not go to.
He may have his own reason, but he did not report for duty.
Because he got.
There was a proceeding.
Yeah.
He is to terminate it.
Yeah.
You approached this court.
Yes, my
The
lord.
court said, consider it in an appeal. The appeal has considered it.
Yes.
Kindly take us to the appellate order.
Yes. Now.
That
what
is the order which has denied you that is the order which has denied you the pay for that period.
Yes.
So we will read that order to find out if it is correctly done or not.
Yes.
Why go into all the history, what
Yes, ma'am.
disease he has and what disease he does not have?
Page 98, my lord. Operative part, my lord.
So, on leave with effect from 10/1. He was supposed to join back on 11/2/2019, date of reporting. Then you did not join. You did not join.
He was dismissed from service on 17/6/2019.
Just a minute. This order has to go, Mr. Goswami. This order has to go. This order, no work, no pay, perhaps has to go. At page 98, the appellate authority says we are setting aside the dismissal order. We are leaving it open to the disciplinary authority to take his own decision based on a disciplinary proceeding. Now let us for the time being say that he was on unauthorized leave. If that is the opinion of the DIGP, he has already framed the opinion. Why do we need a disciplinary proceeding? Not required. Is it not? Now to penalize him for unauthorized absence, if any, first the commandant has to come to a finding that it was an unauthorized absence. Once that finding has not been allowed to come into existence, the question remains whether it was an unauthorized, overstay of leave without sufficient cause, or it was a total unauthorized absence all the time. Is it not? It should have been left open to the disciplinary authority to come to a conclusion whether the leave was unauthorized or not. Thereafter, take a call whether he can be paid anything for the period or not. How can the appellate authority take that call? That is what the Supreme Court says. Once the order is set aside, there will be no orders for payment of salary or anything. It will depend on the outcome of the disciplinary proceedings which may be initiated against the petitioner. And the disciplinary authority will then take a call on how to regularize the leave. Please. 93 years. Huh. Huh. That order is passed. So. We'll be reading too much. If we read from page 96 onwards, unless there is something material, let us not go into it. The conclusion arrived at, which is not under challenge by the petitioner. That conclusion part as to why that order has been set aside, he has been reinstated, the commandant being given the liberty to take up another proceeding, that he has not challenged. He has challenged, why no work notice? That is the issue. Have you challenged the other part of it also?
No.
Your incident you have not challenged. Your liberty to the commandant to start a discipline proceeding against you have not challenged. Not challenged, correct? So now in those circumstances, once the DIGP says that finding of guilt or otherwise and the quantum of punishment except dismissal will be done by the commandant. Law also says that when you set aside the dismissal order for whatever reasons, what has to happen to that interim period? Either it will be Dipali Kundu Silwase or it will be left open to the disciplining authority to find out the amount of guilt involved and then decide what is to be done with the period of absence. How could he have done it? Once he leaves it to the commandant, had he taken the decision that these are the admitted facts, dismissal set aside, reduction of pay by 2 stages, entire period to be no work, no pay, except for the purposes of continuity in service and pension. He could have easily said that. He says, I cannot punish without a disciplinary proceeding. Once the punishment is not there, the finding of guilt is not there, how can you impose the condition of no work, no pay? No work, no pay will only come in because FR also, if you see 50 something, FR also says it will be the discipline authority who will say what is to happen to that period. Once, if there is no penalty, entire salary. If there is a penalty, it will be upon the discipline authority to find out what part to give him. Is it not? He could not have taken this decision. And since thereafter probably there is no disciplinary proceeding. No. Huh? What was that?
And he has been disciplinary option is dash down.
Based on the
Period of answer
summary disposal.
no, dash down for all purposes.
From 10-1.
Now, where I have written the relevant part.
Summary disposal, it will be a summary proceeding. How can you have a summary disposal?
No.
There must be a summary proceeding. Give him a charge sheet, hear him, finish it. Where is your representation to this
Yes, representation,
against this 11304? What did you say?
representation are given.
Diagonal you cannot do.
No, dash down we have no challenge. That representation, because that part.
Diagonal is for the period of your absence.
For period.
Again, he has not done it. When Mr. Goswami? It is only because we don't have time to dictate the order. When? No, that will also give you an opportunity. You can also have the opportunity of telling us whether he could have passed this order on the principle of basis, on the principle of no work, no pay, when he refuses to find out the guilt or otherwise of the person concerned. Moment he found a guilt, it was within his ambit. He refuses to do so. He says, no, you need a full disciplinary proceeding. And this diagonal for that particular period is a negotiation. I will not hold a disciplinary proceeding, admit to your diagonal, we finish it off here. Continue to serve. Is it not? And that was a very minor period, I think, of some few days. So it will not hamper his pensionary benefits also. It will hamper by a few days. So he agreed to it. That's it. When? We'll keep it on the 5th of March possible.
As a part of matter.
Pending, in fact, well, for me, it was delayed. Earlier that I not, that is why he requested me to skip.
I hope by taking up that line, we did not cut short your other arguments.
No, my lord.
Were there any other arguments?
No.
Please tell us, because sometimes we frame a mind and out of habit, we say what we have to say.
No, my lord. As your lordship.
We would definitely like to have something back from the council if we are going on. 18 or given cases, eh?
18 now,
This one?
18 I will not here because I'm okay. 18 to 1, I'm really not here. After 25th,
27 or बहुत असम का? Digo paina 27 February.
as part of the matter.
Matter has been heard at length. List again on 27th of February for delivery of orders. Yes, sir.
This is a case of removal from service. The petitioner Murray CSF constable was removed from service in a disciplinary proceeding, madam. And against that, my lord, removal order, my lord, I conferred an appeal, department did appeal, the appeal was rejected.
What are your grounds, sir?
My lord, my only ground is, my lord, the proportionality of the punishment, my lord. Because the surgery.
How long, what was the allegation?
Allegation is that, my lord, during submission of the first wife, the petitioner conducted the second one. Solomon says second one. This is the main charge. And the lady on whose complaint and FIR the case was registered against the petitioner and he was taken into custody. He was arrested also by the police. And subsequently, the departmental proceeding was also drawn on the basis of the complaint of that lady. Subsequently, she had written to the department that my application I may be allowed to withdraw my applications. I do not want to proceed with my application. But despite of that, my lord, the department, my lord, proceeded with the matter and punished me, my lord, with removal of service. This is the case, my lord. And in fact, subsequently, my lord, the lady, my lord, entered into a mutual agreement with the present petitioner and filed even a mutual divorce petition also before the court,
Which one? The second lady, the one who had made a complaint?
No, the first one. The first one.
The one who made a complaint.
The first one.
They went for a mutual divorce.
Mutual divorce. And as per information, recent instruction of a petitioner.
What about the second wife? Did she appear in the inquiry?
She
Second wife?
was not a part of inquiry, my lord. She is happily living with the petitioner. Both are happily living. They have a children.
You are admitting things you should not admit.
My lord, actually what happened, the petitioner, my lord, during his posting at Dibrugarh, she became familiar with a lady who social media post at Dibrugarh. Out of social media friendship.
We have passed orders in criminal cases that the person to whom we have given bail will not be involved in any sort of social media for the next 6 months.
Well, that lady.
Social media is creating a lot of problem in everybody's life.
My lord, the first lady with whom, my lord, the petitioner married, my lord. That lady, my lord, that lady, my lord, the petitioner came to know that lady, my lord, through social media. Initially, at the very initial stage, then out of social media friendship, my lord, they conducted the special prize. And subsequently, my lord, that lady was not accepted by the parents of the petitioners because she belongs to a different religion, different tribes.
Well, for different reasons, let us say, reasons.
My lord. So ultimately, my lord, when she was not accepted by the family members of the petitioner, present petitioner, so the petitioner conducted the second marriage, subsequent marriage. On the very first of the marriage, when the marriage was going to be solemnized, at the very moment, the first wife, my lord, she came from Dibrugarh. She got the information that he is going to marry another lady. So she came and lodged the affair. And immediately petitioner was taken into custody. Then my information was given to department officers also came. And ultimately departmental proceeding was drawn.
Is bigamy the reason why you were dismissed from service?
Yes.
or because of indiscipline
Indiscipline.
that you are not, that you run around marrying every second and third woman.
Only second, not third, only second, because they will substance of the first place.
Where is the penalty order?
Penalty. And Lordship will find, my lord, the relevant portion,
Eh?
page number 226, my lord, is the final order, passed by the Commander, the department. Para number 16, I-
Gogoi, very recently the Supreme Court has said, no, when Supreme Court has said that when the complaint is itself withdrawn or said to be not.
that will not apply. That will not apply. That will not apply. My lord,
During the period of suspension of the first marriage lawsuit, he has
We
conducted the second marriage, that is there,
The second marriage was,
second marriage was proved, he has admitted, in the repetition also he has admitted lordship. That part not, even lordship, if he, if before lordship, the departmental posting was concluded, then also if the complaint is withdrawn, but second marriage is still there, first marriage is still there. Complaint before the police, lordship,
that was withdrawn.
that was withdrawn.
No,
When-
I think the
when-
complaint was also
when-
made to the,
when lordship complaint is made before the authority also. If that was withdrawn, but that all things are come up before the authority also.
could they do it? This, 3 days before that, the judgment has
that
come
will
in the bar council case.
I have gone to the
That
judgment,
bar council case.
bar council case, that will not do. Bar
Complaint was-
council case regarding that particular advocate from the Kerala High Court senior designation, that was complaint regarding
Someone made a complaint, then the
common
complaint was
behavior,
withdrawn.
sexual harassment.
Yet,
other things.
yet bar council went ahead to hold the proceeding and
Even
analyze.
honorable court, that judgment, honorable court said, observe that bar council is not an employer of the advocate, so the post act is not applicable in the, they cannot apply the
Oh,
mandatory in the
yes,
post
yes.
act also.
That employer-employee relations.
Employee, there is no employee relations, that is on that particular ground that was.
here, my lord, I'll place some judgment of this court and the Honorable Supreme Court also, even in some of the cases, my lord, some other high court also followed the decision of this court in some cases, my lord, and I will also place those judgment also. That our high court judgment was followed by Allahabad High Court in some cases.
And this matter, when was he removed from service?
2020, my lord, final order was in 2020.
You are, you joined the force in 17.
17. Department proceeding was brought in 2020 and removed from service, my lord, by final order dated 5/6/20.
You had your appeal and your revision?
Both were
Appeal and
rejected.
revision done.
Yes, both were rejected. In fact, my lord, after appellate order, I approached this court, my lord, this court directed me to refer the revision. Accordingly, I prefer the revision.
But we have to cut it short because we will not
Only
be
if-
able to take up the matter for disposal today.
My lord.
If we go disciplinary proceeding, it will require some time.
This issue was already settled by the Honorable Supreme Court. Our High Court, one judgment of our High Court is that the removal is lordship too harsh. Removal or dismissal is too harsh, so Honorable Court remanded, division bench remanded the matter lordship for a lenient view lordship. And in
What
that,
was the name of that case?
that case is also I had lordship.
Yes, Rawat. Tilak Singh Rawat.
So, probably it is,
Tilak Singh Rawat. It appeal.
My lord,
কোন CCS কোন আছে নেকি?
if your lordship, I have
কোন ডাঙৰ
only-
CCS
my
কোন
lord,
আছে? তাহন।
my lord, I can complete my application immediately.
Pranab Kumar Nath.
এইখন-
Pranab
এইখন-
Kumar
আৰু
Nath.
এখন পুৰণা এটা version আছে, চাওকচোন, বগা এখন। হা?
Pranab Kumar Nath.
হুম, হুম।
One of the division bench honorable high courts, our high court says that is too harsh, so removal should not be done to reconsideration, compulsory retirement, other things should be done. That was proposed by the honorable high court lordship.
So I think there is a judgment, Tilak Singh Rawat.
Even
Government of
lordship,
India versus TS Rawat.
I will place,
Similar.
I will place the recent judgment of Supreme Court. Lordship, on the basis of the our high court judgment, so many high court passed the order in favor of the same kind of offences. That was negated by the Kerala High Court. Then it was come to the Honorable Supreme Court, Jharkhand High Court lordship. Honorable Supreme Court recently held that. Just one line I read out lordship. Just one line that particular famous magazine lordship. Dura lex said lex lordship. The law is to be heard, but law is the law. On the basis of that principle, that CISF person's lordship, that dismissal order was
Upheld.
upheld by the Honorable Supreme Court. Law is already well settled lordship. exactly similar situation, same facts, same cause of action, Honorable Supreme Court, same company, CISF Lordship.
2003 GLP 558 was the first case decided by this court regarding bigamy. Page 491.
But ultimately, we go by
The
the,
law has
we
undergone
go by the law laid down by the Honorable
must
Supreme
change,
Court.
must change. That point of time, it said, agreeing with the submission of the counsel for the appellant that in another case, extreme penalty for dismissal of service was not imposed. Court hereby set aside the punishment of dismissal from the appellant and leave the question of imposition of lighter punishment to the disciplinary authority. Profullo Kolita.
Yes.
It followed Profullo Kolita
Then,
1995.
then Pranab Kumar Nath in 2023, our High Court CISF person said that it's too harsh, it should be compulsory. On the basis of Pranab Kumar Nath, Allahabad High Court and another two High Court passed the judgment by relying the principles laid down by the division bench. Our Honorable Supreme Court has already Lordship settled the issue, Lordship.
Pranab Kumar Nath.
My only submission is, my lord, here, it will be, the misconduct, committed by the petitioner, it is not in respect of his public duties, my lord.
Office?
Of his public duties. While discharging his public duties, he did not commit anything wrong. The entire charges are related to his personal life, personal affairs, that solemnizing his second marriage. The lady who is the aggrieved here, the first lady, the first wife, she herself has written to the department that I have no objections. I be allowed to do my applications. So I do not want to proceed with the matter, and my matter be erased. So in that matter, if the lady she is not aggrieved, how the department, my lord, can take a
ASF এখন আছে না? ASF এখন Central Industrial Security Force Act.
And the punishment prescribed are almost same with the, the Central Civil Services, that the CCS rule, my lord. The punishment prescribed under the CISF Act and the CCS Act, my lord. Both are same, my lord.
Any misconduct?
Well, I have to place some judgment of the Supreme Court.
Yes. We are not disposing anything. We are just trying to understand and refresh our memory.
I will place very recent and the very earlier judgment also of this question, very relevant judgment, my lord. And because the solemnizing a second marriage, the allegation of second marriage and the sexual allegation both are different, my lord. In fact, in some of the cases, my lord, some of the High Court took the view that even the allegation of sexual, the sexuality with or adultery, my lord, that also is a personal affair. That is also a personal affair.
Absolutely personal
Not in
affair,
that
but when the appointment of a person who has two wives is itself a disqualification. Can a person after entering have two wives?
No, my lord, here,
These are questions which may come.
bigamy under IPC earlier, under 494 IPC, now it will be a different section of DNS. That section has been interpreted by this court in some of the cases.
We'll see, please pick a date in March. Anything in March? Choose a date.
Second or third month, any.
Second or third. Second is a motion day, third and fourth, I think it will be colorful everywhere. We shall not be attending fourth. Some other day.
But end of this month.
End of this month, we have stacked up a lot of matters. That will be on 10th? 10th of March?
Mostly 10th of March, I have to matter fix in CAT, Single Defense Private.
12th of March? 12th of March. The pleadings are completed in the matter and the matter was listed under a column hearing, full stop. Paucity of time doesn't allow the matter to be taken up for disposal. Place this matter again on the 12th of March under the hearing column.
All right.
That is one part we had missed. that employer-employee part in the bar council case, somehow it missed our attention. Yes, the moment you said employer-employee, everything fitted in. Then things fitted in, how that should be done.
May I please, your lordship?
Yes,
Lordships, the petitioner, my lord,
it is
was,
regarding what?
it's a retirement benefits, my lord.
Retirement benefit.
They
Why
have,
has it not been released?
my lord, they have filed affidavit, my lord.
Saying what?
There, because of some silly reasons, they are not paying, my lord.
Oh, don't use terms which you,
First, they are saying, my lord,
huh?
in their para 5, page number 30,
Yes.
they are saying that the petitioner, he had took one personal loan from one person, and he wrote one letter, my lord, to the corporation. And we have replied only, my lord, we have annexed one document also that he already returned that money, my lord.
How is it their business?
That is not relevant in,
At that point of time, that letter was not given. Not
Which letter?
that loan.
No. Anybody's employee takes a loan, you stop his pension.
It's not like that. He has taken the loan from a depositor of warehousing corporation.
So,
From a depositor.
So?
And the depositor has earlier stated that he is a.
did he have a court order for stoppage of pension? Trouble. Then,
Then, my lord, second reason, my lord,
Pension.
SBI wrote them a letter, my lord, saying that I have a personal loan with SBI. That is the second reason, my lord.
okay.
Nothing more than that.
Aparna Devi versus Union of India. Have you gone through it? Aparna Devi. No. Very good. Don't go through judgments. Yes. Don't go through judgments.
We have already paid some amount. CPF has been paid.
When will you pay the full amount to him?
There is severe financial crunch and DA and other allowances are.
Had it been paid at the relevant point of time, there would have been no crunch. Persons who are now in service, drawing salaries, no crunch.
But some
Let there be no crunch when the payment of pension is concerned, because otherwise there will be squeeze where the question of salary is concerned.
might not agree because of the financial crunches, they are going to release the payment very soon.
No.
And some developments are
Stop,
going on.
stop the salaries, get the pension paid first.
That will be paid. Not that we are not going to pay.
When? See, we are not adjudicating the issue today because already they are seeking time to try and
We'll get
finalize
further
your pension.
instructions and we will get it paid.
Or it can be done in such a manner, we can have it listed, proposed for mediation in the next 2 weeks. Let it come up in the referral for mediation. You will have some time of 2 weeks. It will go to the mediation. You will have another time of 1 week. Before the mediation, record an agreement that this is the time frame we require.
These are financial positions and we have paid this.
We can pay this much.
All employees are at par because existing and other employees also,
All
DA,
employees-
as far as DA is concerned, so we have not released any DA for some existing employees also.
Huh?
They are-
No,
we have
some,
Some existing employees,
to whom has it been released?
earlier, my lord, earlier DA,
Serving, who are getting it?
serving,
we see, if these are the kinds of stand the respondent takes, what we have to do is this. We will start the payment bottom up. The payment will not filter down. The ice will not come from the top to the bottom, becoming a mere piece of droplet of water by the time it reaches the end. You will see it is an iceberg. It will burst out of the water, take away everything to the top.
they have devised some developments are going, they have devised a plan, how they will pay and what will be the mode of
Yes, sir.
payment. So I will take instructions and I will, in 1 week, we will be prepared.
Simple issue is you are stopping a casual scaleman come
Yes.
beyond.
Agree.
There must be an MD. There must be an MD. There must be a senior finance accounts officer. Are they getting the full benefit of what they should be getting?
That we are not aware, and I am not aware.
Should be, because you're stopping someone's pay. Role model employer cannot keep the employee hungry. Did not.
He retired on 31/7/2022, my lord.
22, and what is remain to be paid to you?
My lord,
What
page number 8. I have
Huh?
Page number 9, my lord.
page number 8. I have prepared a list, my lord.
On the next day, I heard Mr. S. Dr. Learned Council appearing for the petitioner. Also heard Mr.
B.D. Chaudhary,
B.D. Chaudhary Learned Council appearing for the
3/4 respond.
State Warehousing Company and Mr. Appearing on behalf of the respondent number 1. The learned counsel for the respondent number 234 prays for a short accommodation to inform this court as to when the benefits as spelled out in at paragraph 7 of the repetition is proposed to be paid, and also the manner in which the said amount is required to be paid. So now just tell us, has he received the CPF amount?
Yes.
CPF received?
Yes.
Yes, sir, we are going
The
from bottom
provident
down.
fund, my lord, they have paid.
Page 9.
Yes, my lord.
No, page 9 of your read petition. Yes, that is what you are referring to. Tell us what you have received.
My
Have
lord.
you received CPF?
My lord, I have stated in
CPF
paragraph 6, my lord. The provident fund, my lord, they have paid as per old scheme, but he is entitled for new scheme, my lord.
Gratuity?
My lord, the paragraph 7, these are the lease, my lord.
Of what you get,
Yes.
what you have to get.
Yes, yes.
During pendency, have you got anything?
No, nothing.
CPF and leave encashment has been paid, leave encashment partly.
D, kindly see D.
Hill allowance, remote allowance.
Bill allowance is the part of the gross pay, that is all.
Kindly see B. Page 8.
Page 8.
Page 8.
Area dareness allowance.
Just a minute.
That is about to pay.
This 7A, you would give us a calculation. B, you would give us a calculation. C, there is a definitive sum of 7,358 rupees.
As per his.
E, 10,560 rupees. These are definitive. Whether he gets other benefits or not, whether calculation will take place, whether they are huge amounts or not. These are not even petrol bills.
And the hill allowance already been paid with the gross pay.
Which one?
Hill allowance.
Tell us that. It is there in the affidavit.
We mentioned in the affidavit.
Yes, sir, you D.
My lord, as per, my lordship may kindly see their reply, my lord, what they are saying about hill allowance, my lord.
Okay, then this will take some time. We do not
Yes,
have as of today. I shall inform this court. Short accommodation to inform this court. Benefits as given at paragraph 7 of the writ petition are proposed to be paid in the manner in which they are proposed to be paid. Please this matter again on
As per court's confidence.
March first week, second week delay. 9th of March,
My lord.
on which date the learned counsel for the respondent number 2, 3 and 4 shall apprise this court. The man has gone from office. Some sacrifice by somebody has.
Understood, my lord. My lord, I am also sympathetic to him.
So I'm appearing as
Supreme Court
legally.
in one of the matters had stopped the salary.
Yes.
And everything was paid.
He understood.
We will not go to that extent. Yes, next.
I love it.
28. What's the matter about?
My lord, I think the petitioner is happy with the,
No one has appeared to him.
from 2023, my lord. My lord, seeing the chronology, the matter was filed in 2018. Petitioner retired in 2019, got everything pensionary benefits under NPS. Thereafter, the council stopped appearing. Now we are in 26, in all the orders, none appears.
Petitioner got benefits under NPS. Nobody else got any other benefit. Therefore, the appearance of the matter was notice in the matter was issued on 23/5/2018. None appeared on 28/8/2023, 8/9/2023, 13/10/2023, and 3/1/2026. Learned, Mr. Ardhar, learned counsel appearing on behalf of the respondents has submitted that he has specific instructions that the petitioner has received all pensionary benefits as admissible under the NPS rules. Full stop. In view of the non-appearance on behalf of the petitioner and also the submission that the petitioner has received all pensionary dues under the NPS, this court is of the opinion that the petitioner may not be interested in pursuing this litigation any further in view of the above, which is closed. Full stop. However, petitioner shall be at liberty to revive the petition in case any events sought to be agitated in this writ petition remains. The petition disposed of. Today's list disposed of.
The whole day, even the council's name were rolling in the thing. Also. I mean,
You
we have
make it a point. There were times when
Did
we
not-
missed it.
material instruction did not arrive.
Even we missed it by sight.